We will start as soon as our last panel member comes back. Okay. Good afternoon. For those of you who were not here this morning, all of the material is on our website. The material from the hearings will be on our website shortly, in a couple of weeks. And the way that we're doing this is the witnesses get to make statements, and then Copyright Office personnel get to ask questions, hopefully ask questions that help us move forward. And later we may submit to people who specify additional questions that usually come up as a result of the hearing today or next week in Washington, or later as we consider the exceptions and what has been submitted. You can see our names up here. I'm Mary Beth Peters, Register of Copyrights. To my left is David Carson, General Counsel. To my right is Rob Kasnick, who has been involved in every one of the 1201 proceedings. We probably call him Mr. 1201. You haven't heard that. And he is Principal Legal Advisor, Assistant General Counsel in the General Counsel's Office, obviously. To David's left is Ben Lodge, who is also a Assistant General Counsel, Principal Legal Advisor. And so we will now basically focus on a variety of classes of works that deal with computer programs. They're labeled 5B, 5C, 5D. And the anyone want to talk before? Okay, who's going first on this side? You are. Okay, Peter, why don't you start?
Thank you very much. My name is Peter Lurie. I'm General Counsel and co-founder of Virgin Mobile USA. I appreciate the opportunity to participate in the proceeding. With me is Christian Berger, who's Senior Director of Mobile Devices, and he'll be testifying about the more technical aspects and speaking more intelligently about them than I can. Quick background on Virgin Mobile USA. We founded the company for a single reason, and that was to offer an attractive, competitively priced prepaid or pay-as-you-go service in the U.S. Before we got into the market, prepaid was what you got if you couldn't pass a credit check, or if you were unwilling to commit to a 1 or 2 year contract at $40 or $50 or $60 a month. We think that our success has proven the concept. We're the 6th largest wireless carrier in the U.S. We've got over 5 million customers. Our handsets are available at over 40,000 stores, including Best Buy, Target, Walmart, Radio Shack, and replenishment cards at over 140,000 locations, grocery stores, gas stations. We do not set out to build a network. We do not set out to build bricks and mortar stores. We focus on the customer experience. We design the service plans, the pricing, the website, the content on the phone is very important. The website, customer care experience, the marketing materials, anything the customer experiences or touches, we design and we build. We've also pioneered the grab-and-go model of handsets, where you can go into a store that doesn't necessarily focus on wireless, such as a Walmart or a Best Buy, and without too much sales help, walk out with everything you need, call us up, get online, activate the service. And that has dramatically lowered pricing for our customers. Although we say a value-oriented product, it's not a bare bones product. So it's a rich multimedia product. The device has messaging, text messaging, picture messaging, music, games, ringtones, an array of copyrighted content. As I said, we don't impose credit checks. We require long-term commitments. And what we found is that this service is particularly attractive to low-income customers. About a third of our customers in households with income of less than $35,000 a year. Half of them are new to wireless. When they leave, interestingly enough, half of them who leave don't leave for a competitor. They're not taking their phone elsewhere. They are leaving because they can't afford wireless, which is really interesting because our service is very expensive. We spend a little $20 a month on service. And it's troubling because wireless does have real social benefits. The MIT Legacy Center for Development found last year in a study that wireless provides low-income consumers with increased job retention rates, personal security, access to emergency services, real specific benefits that they lack when they are priced out of the wireless market. And we think that we've played a broad role in increasing access to wireless service to low-income consumers. And in fact, our success has really, I don't think it's an overstatement to say that we've revolutionized wireless in the U.S. All of our competitors now have very attractive and very competitive prepaid services, whether it's Go phones or Verizon, Sprint Boost products. Really, we created prepaid as a growth area and expanded access to wireless service. Let's talk a bit about our handsets very briefly. We sell our handsets at substantial discounts. We pay more to the manufacturer when we sell them to the consumer. We subsidize them. The subsidy is greatest for the least expensive handsets that we market. We sell them at substantial losses. To do that, we expect that those handsets are used with our service. We are able to provide this because the handset has security software that protects an array of copyrighted content and also limits for use with our service. And again, we don't require long-term commitments. We can't rely on a 2-year contract to ensure that we get our revenue, our investment back. We have to make sure that our service is competitively priced every day. The handsets are packaged in terms of purchase. Right on the package, it says you can't alter the software, you can't alter the hardware, you must use it through Virgin Mobile service. so too the terms of service in the package on the website. Again, these are critical aspects of the business model and critical in protecting the copyrighted content on the phone. If we were forced to sell handsets without that security software, handset prices would at least double. So what we think is that we think there is a lot at stake with this proceeding. We don't think that the fact that the exemption has existed for 3 years without handset pricing having increased is indicative of what will happen in the future. We've had to make substantial investments in security software in our handsets to protect the copyrighted content and to protect our handsets against reflashing. We have launched over 30 lawsuits against an array of networks that purchase our handsets in bulk, hack them, and sell them overseas at a price, the market price in that handset. So they're capturing their subsidy. We won all those cases because the practice is frankly unlawful. It violates our rights. And what we think is at stake here is not a legitimate customer who wants to take their handset to another competitor. That's not actually what's going on. There may be isolated instances. Consumers have a view of how long their handsets are attracted to them. Handsets are expensive. They get more and more inexpensive, and they improve in functionality and design. We find that our customers, our best customers, actually are buying handsets for every 6 or 8 or 12 months at a substantial loss to us because we don't charge them more simply because they're an existing customer. There are a number of reasons why customers don't want to take their handsets to another service, one of which is that you'd like to get a new handset. Handsets are relatively expensive. And another is that in the US, a lot of different carriers have a lot of different technologies. So we use, for instance, CDMA network. You could take our handset and use it on the Sprint network, but you couldn't take it and use it on the Verizon CDMA network because we use different frequencies. You certainly couldn't take it and use it on an AT&T GSM network, and presumably we're not, the request is not to offer very, very expensive quad band handsets that would work on all networks. Let me just run through our principal arguments. The first is that the proponents of the exemption argue that the handset security software doesn't protect copyright interests. That's false. The handset security handset software, the security software directly protects music, graphics, ringtones, the operating system. The requests for proposed exemptions are themselves directed at non-copyright purposes. This is not a request for legitimate use of copyrighted content. This is simply a request to use this proceeding to enable free riding schemes. There are those who would take the investment that we're making, the handsets that we're selling in the law, and repurpose them for use with their business, and effectively increase handset prices for everyone, for low-income consumers. Again, I do not believe that this is about consumers taking a handset for use on another service after using it with one service. Again, there's certainly isolated instances of that, but this is really about using the proceeding to protect the business model. It's free riding, it's illegitimate, and would be damaging to a broad array of consumers in the U.S. Our handsets are not just pieces of hardware. It's not a toaster. It's not a garage door opener. It's a sophisticated multimedia device with an array of copyrighted content. The security software is akin to CSS that protects DVDs. It's not. There's no logical difference between the two functions. And again, this is really. I think this is about enabling a business model that would increase prices across the country. Finally, the proponents argue that there will be environmental benefits. That also is untrue. We are actually the first and remain the only carriers in the country to offer prepaid return envelopes for every package of all of our handsets. So you're done with your handset, you want to return it, you want to recycle it, you send it back to us, we'll recycle it. California has a recycling line, and it's also a wireless device has to accept it back. Again, because there's no evidence that repurposing handsets would lengthen their use in service. Again, consumers have a view of how long those handsets are attractive. And number two, because what's really happening here is not in allowing legitimate customers to repurpose handsets, but enabling free riders to hijack a subsidized phone that's used on their network. You're still starting on day one from that view. The handset starts on day one. There's no second life to that handset because it isn't being repurposed by a customer who's already used it on one network. It's being activated for the first time on a network for which it was not designed. Talk about our copyright interest in the handset. Again, although we have a value-oriented product, it is not a bare bones product. We deliver our phones with preloaded ringtones, games, software, a user interface that we designed and have a copyrightable interest in, an operating system that the handset manufacturer designs and owns that we are obligated legally to protect. In fact, our agreements with, say, major music companies to provide music on the phone require that we protect the content on the phone. If it became unprotected, they would terminate our agreement and we wouldn't be able to deliver their content. There's been a suggestion that instead of using the security software to protect all the content, we should invest in much more expensive, much more complicated DRM that would attach to each piece of content. That's not feasible for us. Our chipsets and our lower-end handsets don't support DRM. If you don't support DRM, we use the handset security software to protect the copyrighted content. And in fact, I don't believe, and Kristen will talk in more detail, that DRM would protect Java-based applications. If you unlock our handset, you have access to all the copyrighted content on the handset. You can repurpose it for use on another network if it were to work on the network, but you would also be damaging what is the DRM, but it is handset security software on the phone. And again, our more basic chipset doesn't support that type of complex DRM. Proponents argue that the 2006 exemption has increased the availability of handsets and not renewing the exemption would lead to a decrease of their availability. Actually, the reverse is true. Because we've been able to stay one step ahead of groups like you off the top, through a significant investment on our part, we are able to sell our handsets at a substantial discount, $10, $15 in the marketplace, without requiring customers to enter into 2-year contracts and spend $50 a month on them. Handsets, that means that a customer can buy a $10, $15 handset, use it for a period of time, and buy another one. That is increasing the availability of handsets. If we were unable to secure our handsets and we were unable to our technology were superior to what the handset unlocking technology, our handsets would quintuple in price. The number of handsets would decrease, and consumers would probably have to either spend more upfront for a prepaid service, and assuming they can afford it, or engage in a postpaid service. Remind that there are an array of unlocked handsets out there. If you're a postpaid carrier and you offer a postpaid service, you can offer an unlocked handset because you know that with a 2-year contract, you're going to recover your investment. You can offer the same device at 2 different prices, a higher price with unlocked without a contract, and a lower price, subsidized price, unlocked with a contract. We don't have that luxury. We're very focused on this model, on this area of the market, and we serve them very well. We think that a company that is trying to prevent free riding is not showing access to wireless services. We think that we've been, as I said before, I think we've revolutionized access to attractive wireless services. The proponents also argue that we are not protecting any copyrighted interest. As I noted above, ringtones, graphics, games, we offer an array of downloadable content. It's all copyrighted content, and it's all protected by the handset security software on the phone. Finally, again, the proponents have argued that there are environmental benefits, and I noted that we have a comprehensive recycling scheme, and there is no evidence that recycling handsets increases the handset life and means that a handset ends up in a landfill if it were not recycled any faster. Yeah. And that summarizes our position here. I'll turn it over to Kristen.
All right, thank you for listening to, I think, 3 points that I'm going to talk about. My name is Chris Boja. I'm the engineering manager at Virgin Mobile. I'm going to talk about 3 points. One is I'm going to describe the handsets and technology that we use and the technical protection measures. Secondly, I'm going to describe the copyrighted materials on the phone, on the real phone, using the information on the screen. And then thirdly, I'd like to describe the consequences of unlocking a handset, both from the perspective of sharing those copyrighted materials, as well as any other consequences that might be about the functionality of the core functionality of the phone. Virgin Mobile uses CDMA handsets, which are technically quite different to a GSM-based handset. There's no SIM card. The concept of SIM card doesn't exist. For many core functions of the key technical protection measure that's being used is called an MSL, Master Subscriber Lock, and that Master Subscriber Lock is essential in protecting a number of functions of the handset. One is certainly it's used to protect the handset from any kind of attempt to being reflashed. The second core protection measure or purpose of the Master Subscriber Lock is the access to the embedded file system. And the embedded file system is really the location of all of the copyrighted materials. And if I could draw your attention to either the screens or the handout, that would be great. So as Peter described, cellular handsets are a combination of software, content, and hardware. And Virgin Mobile devices really are a combination of content that is either generated by the handset manufacturer, the OEM, such as Samsung or LG, Virgin Mobile, which could be graphical assets, sound assets when the phone boots up, or third parties. And third parties could be anything from Google Maps to electronic arts, Tetris, any kind of game, or ringtone, or wallpaper. And all these components are created and combined to create the device binding. If you look at the screen, the file structures that are used really vary by OEM. Every manufacturer has slightly different file structures, and the screenshots below are really just for reference. But I think they provide you with an illustration of what the memory locations of where the copyrighted works reside really look like. And they look very similar to what you might see in a Microsoft Windows kind of environment. So in the first screenshot, you actually see the directory of any kind of preloaded Java applications. This typically includes the JAS and the jar file for the application, or a PNG file, which is an image file for the thumbnail to identify the application. On the next screenshot, you see directories of preloaded screensavers. Again, Virgin Mobile owns the copyright to a lot of these materials, or preloaded wallpaper. One of the key points that Peter made earlier as well is we have extensive relationships with content vendors to ensure that the content that a user might download or purchase to the handset is adequately protected. And there are hundreds of thousands of pieces of content, whether it's ringtones, wallpaper, screens, games, etc. All of that content is also freely accessible in the embedded file system. So on these screenshots, you actually see the directory of preloaded ringtones, which are just plain MP3 files. And the same applies to the directory of purchased ringtones. All of this information that you can see here can literally be dragged and dropped onto your PC, and then you can any kind of malicious user could choose to share this content through a peer-to-peer network or through any kind of internet-based distribution system. You could even email it to other people. One of the points that Peter mentioned before is because of the economic model of Virgin Mobile, many of our handsets use technology that falls more within the value tier of chipset manufacturers. And these types of chipsets really do not support kind of extensive digital rights management software or any kind of protection mechanism that are outside of the kind of more industry standard MSL mechanism. The other point to make is that DRM technologies in the mobile world really focus on only specific types of content, typically around single-track music and single-track video. However, there's no comprehensive DRM technology out there for wallpapers or Java games. So, one set of technologies cannot be used to protect every single type of copyrighted content. Another type of copyrighted content that is on our phones are all the graphical assets that represent the Virgin Mobile brand. DRM mechanisms simply do not apply. So adding additional software-based or hardware-based security features would certainly mean for us to purchase much more expensive devices, and would also have an effect that we would limit the number of phones that we would be that we could sell. One of the key points that we wanted to make is that and this is really talking about the consequences of using copyrighted works after the phone has been unlocked and made available to a different to work on a different carrier. Should this happen and a phone has been unlocked, the copyrighted works, particularly the Virgin Mobile USA assets, are still being used in conjunction with the new information or software that is put onto the phone. So even though the phone is now being reprogrammed to work on a new carrier, the existing Virgin Mobile assets, both those that we license as well as those that we own, are still being used in that context. So let me give you a concrete example. Just because you reprogram the phone to work on a different network operator, your version of Tetris will still work, will still run. The phone will still play the Virgin Mobile boot up jingle when you power it up. It will still show all the Virgin Mobile assets, all the graphical assets. The last point that I'd like to make is also the functionality and security that could be compromised once the handset is unlocked. In the Cricket testimony, there's actually a very clear statement that as part of the unlocking process, both the PRL, the preferred roaming list, as well as memory locations would be affected. And those memory locations are the exact repositories of all of the copyrighted works. Changing the number of these locations could also mean a loss of functionality of the handsets, because content that a user may have invested in and purchased from Virgin Mobile may no longer work. Other functions such as MMS may no longer work. And the final point that I also want to make, one of the consequences that may create, and it's outlined in the Metro testimony, is that unlocking a handset will almost potentially invite the user to illegally or non-lawfully use the handset. One of the key things that would be very hard to enforce afterwards is once the phone is unlocked, to prevent the user from actually stealing airtime on the new carrier's network. It also, as Peter made the point earlier, it would be very difficult to actually create technology once the phone has been unlocked to prevent it from being sold in India, for example, which is a popular destination for companies that are engaging in qualified purchases of stealing hands. Thank you.
Okay, thank you very much.
Thank you very much for having me here to testify about this exemption. It's nice to be back before the Copyright Office. I am Jennifer Granick. I'm the Civil Liberties Director at the Electronic Frontier Foundation, and I'm here today representing 3 handset recyclers: the Wireless Alliance, Recellular, and FlipSwap. The Wireless Alliance is a Colorado limited liability corporation that recycles and resells used, refurbished, and new cellular products. That client sells between 40 and 60,000 phones per month. Recellular is the world's largest recycler and reseller of used cellular phones and accessories. Recellular is a partner with DMCA and with Virgin, and worked with the Wireless Foundation of DMCA on its original Donate a Phone charitable program. Recellular donates millions of dollars to charities and recycles or reuses tens of millions of phones, almost 6 million phones last year. And FlipSwap is a company that offers fast and free ways for consumers to trade in their handsets in exchange for cash, gift certificates, or store credit. We are here seeking a renewal of the exemption that the Copyright Office granted in 2006 for phone unlocking, but with a change. DMCA in its filings recognized that an exemption is warranted because customers have good cause who want to unlock their phones. So the question is not whether to renew the exemption, but what the scope of that exemption should be. And we are here today asking for something very simple. If I own a phone and it is compatible with a particular network provider, and that provider wants me as a customer, I should be able to use that phone on that network. This is a no-brainer when you think about going and getting your car serviced somewhere. But because a handset is both hardware and software device, the DMCA inhibits this customer choice. And to vindicate this simple right, the Wireless Alliance asked for the exemption in 2006. Now we're here asking for the Copyright Office to remove the clause of that exemption that allows the unlocking solely for a non-commercial purpose. And the reason why we're asking for that is because a few district courts have misconstrued that aspect of the exemption to not apply if the unlocker has some kind of financial interest in the unlocking. And this is very problematic to my clients, because my clients, while they're in the business of doing good, also want to do well. They sell these handsets on the second-hand market. And it's also problematic for the consumer, because consumers have many legitimate economic reasons why they might want to unlock their phone. Either to save money because they bought a second-hand phone, because they want to resell their phones, they want to save money while traveling internationally, to save money by switching to a new plan. So the idea that only where there's no commercial purpose whatsoever is unlocking okay is basically emasculating the exemption that was granted in 2006. And that's why we asked the Copyright Office to remove this limitation. Now, DMCA accepts the need for an exemption, but proposes even narrower language than was granted in 2006. And this language would eliminate the existing safety valve what we have, and would limit it only to individual customers who unlock solely for a non-commercial purpose, comply with all contractual obligations, and then only if the provider does not also use the network lock to control access to other work. And unfortunately, this formulation of the exemption doesn't help my clients or your average consumer. We talked about why the non-commercial clause is a problem, but the contractual obligation clause is also a problem. First of all, my clients and other recipients of secondhand phones don't have contractual obligations with the provider. So it's not clear under CTIA's formulation whether the exemption could apply to us because there's no contractual relationship. Further, it's very difficult for courts analyzing 1201 claims to determine whether to grant motions to dismiss in unlocking cases without doing fact-finding on the contractual issues. Also, these contractual issues are not the interests that the copyright law seeks to vindicate. Those are business model interests that the office recognized in 2006 are separate. And finally, whether or not the customer or the possessor of the phone has fulfilled contractual obligations is probably not known at the time of circumvention or unlocking, since when you do have a contractual relationship, it lasts over a period of time. I think the comment by eBay in support of this exemption indicates one of the kinds of problems that their customers, secondhand phone sellers, have when you have an uncertain applicability of an exemption hanging over their head. And they pointed out that in their verified buyer program that they get a lot of improper and potentially chilling complaints through that program that interfere with the market for secondhand phones. Then finally, the idea that the TPM controls access to no other work is a severe limitation that basically takes away the benefit of the exemption. Because, first of all, there's no way for the average phone unlocker to know whether the lock controls access to other works or not. Most people who unlock their phone don't have any way of telling whether something like Virgin MSL or the usual STC or SIM-lock is related to TPMs on other content. And also, it means, as we discussed during the 2006 rulemaking hearing, that network providers are able to construct the phones in such a way that the same TPM that locks the phone to a network also controls access to any other code, and thus the exemption doesn't apply, putting the question of whether the safety valve exists totally within the power of the manufacturers and providers and not in the purview of the Copyright Office or the librarian. So, there are even more compelling reasons to grant this exemption than there were in 2006. One reason is that recycling has grown, but not nearly enough. The estimate is that there are 125 million phones per year that are retired, and 80% of those phones are serviceable and would work on networks. My client, Recellular, which is the largest phone recycler, recycles about 6 million phones. So that leaves almost 120 million phones, 80% of which work perfectly fine, but end up in landfill. We need to do what we can do to try to make the life of these phones longer. The idea that if you unlock a phone so that it can be used on another network, unless there's that many more customers who can purchase it and who might be interested in buying it, that does nothing to keep the phone out of the landfill is simply false. And I provided to the Copyright Office the report from Recellular about its program for phone reuse and recycling. And these companies basically do everything they can to try to keep the phone in an active life and give it to a person who wants to use it and satisfy that need. And only at the very end of the phone's life, when it can't be used anymore, do they recycle it. That reuse is the best way of recycling a phone, and only later is trying to chop it down into its constituent parts and metals, the next most environmentally friendly method. Second, there are basically two kinds of locks that we're talking about in 2009. One is the locks that are on CDMA phones, and the other is the locks that are on GSM phones that lock the SIM card. Now, I understand, we can talk, and maybe I'll leave it to questions that the panel might have about how the unlocking works. But one thing we know is that under some circumstances, most of the providers of CDMA service do unlock their phones. So they don't have concerns in those circumstances that there are other copyright interests at stake. They unlock the phones for their customers under certain narrow circumstances. And I want to talk a bit about what that means when the customer unlocks the phone for themselves, because we know that providers will do it in narrow situations. So I provided you with a printout from the Virgin Australia website that's just a kind of compendium of different methods for unlocking phones. And I just want to run through the two main ways that people do it. So one way is when you know what your STC code is. And then when you know what the STC code is, you do it depending upon the model of the phone according to this printout that I provided. And you type something into the keypad of the phone to bring it to the service screen. And then you type in the STC code, and then the phone is unlocked. And the question is, well, how do you know what the STC code is? And people are able to buy STC codes for various phones over the internet, or to calculate the STC code based on the algorithm that the carrier uses. So very often the codes are built off of the unique serial number on the phone, and there's an algorithm that changes that into a particular code number, and when you type that code number in, the phone becomes unlocked. So this is one way. Another way is to use a tool to read the data that's on the phone and to clear the STC value that's stored on the phone and put another value in, for example, all zeros. And that is another way that people can unlock their phone. Now, in both of these situations, basically what you're doing is you're finding the place in the phone's data registry where the STC code resides, and you are either entering the correct code or altering that piece of data to a code that you know. This is not changing the binary of the software on the phone any more than when I type my PIN number into the ATM, I'm changing the binary on the ATM machine. This is a registry of data that is something that is stored in there that the software on the phone looks to and acts on, but it's simply a number, a piece of data. And when I change that piece of data, it allows the user to change other parameters, other data sets on the phone, like the preferred roaming list, which is the list of towers or services for the handset to look for. And if you have other questions about that, I can try to answer them. And then the final thing the final method is the method of reflashing, which is basically a total rewrite of everything on the chip, where I just put an entirely new operating system, entirely new software on the chip. And many providers give that software away for free. And what it does is it takes the existing software and it's gone. And there's a new thing there. Also, since the last rulemaking, we have some policy statements from the FCC about open devices and open wireless networks. And the acting FCC Chairman Cox has made statements that open applications and open device requirements for broadband stimulate innovation for both internet and for wireless providers. And that the FCC will continue to look for ways to promote open access conditions and to monitor spectrum acquisition and anti-competitive practices in the wireless market. And I would direct your attention to the comments submitted in support of our exemption by the Public Interest Spectrum Coalition on this point. And then finally, since 2006, a very important point is that we have seen no evidence of infringement or harm to copyright interests as a result of the existence of this exemption. And if you look at all of the submissions from all of the opponents, nobody is saying that copyright interests have been compromised by this exemption. Virgin says there's been no handset cost increase. The problem that they have is really a problem with people who are the bulk purchasers and unlockers. And as in Virgin's case, they bring lawsuits against these people. I don't know, and I'd be interested in hearing whether those lawsuits make a 1201 claim or not. I know that in the TracFone lawsuits, those lawsuits do make 1201 claims. But those claims are one of a set of claims, including trademark infringement, contract violations, unfair competition, and other legal remedies that TracFone has found also very useful in pleading in those lawsuits. So, specific responses to filings by Virgin or CCIA. First, I would point out that courts have not held that unlocking phones is an infringing activity. In the cases cited in these oppositions, what in Trackphone versus Dixon, that's the case where the defendants admitted their liability. There was no dispute and no finding. The Thomas case is a default judgment case, and the Bitzel case is a consent judgment case. So there are no cases where courts have looked at the technology of unlocking and found that practice to be infringing. Next, in terms of the copyright interest, what our exemption is asking for is for a class of works that are works that control acts that the handset uses in order to connect to the mobile network. We are not asking for an exemption for access to classes of works that are ringtones or wallpaper, or even to the user interface that a company like Virgin puts on the phone. It's not clear from the submission why it is that, or how it is that Virgin claims that these are copyright interests that are at stake. What their submission basically says is that because customers are supposedly subject to some kind of sale license, whether it be shrink wrap or click wrap license, that they will stay with Virgin and use the device on Virgin's network, that when they fail to do so, they are somehow infringing copyright. I think there's a serious question as to the enforceability and interpretation of those terms of sale or terms of use. But even if there is a valid contract here, this is an entirely non-infringing activity under Section 117. The phone purchaser is an owner of the phone. Under Kraus versus Peddleser, the purchaser has the right to lawfully use and keep the phone forever. He can throw it away, he can put it in the trash, he can give it to somebody else. And these are the extent of rights that owners have that give them the rights under 117. Now, if the firmware is stored on the device and the provider has no right of repossession, and even when the relationship is terminated, then 117 should apply to further use of that firmware and probably also of those purchased ringtones and even the operating system. And there is no wireless provider that I'm aware of that tells users that when they sell you the phone, you have to give the phone back to them or you're not allowed to dispose of it or any of those kinds of limitations. That means that the normal customer is not a 117 owner. So 117 applies in probably every case of sales of phones. Furthermore, fair use applies. I could go through the various factors, but I think one of the most important things to point to is that there is no market for this firmware outside of the handset. The handset and the firmware go together, and the value of the firmware is pretty much entirely with the functionality that it provides for the handset. On the issue of whether it is a satisfactory alternative for carriers to unlock, first of all, Virgin doesn't unlock their phones. And carriers only unlock under certain very narrow circumstances. Carriers don't have an incentive to unlock because they get a volume discount from manufacturers, which means they want to move new products. Customers report that they have trouble getting phones unlocked. Carriers tell you that they only unlock when you are an active customer, and then only if you've met certain circumstances, not always clear from their terms of service. And those circumstances simply don't apply to people like my clients, who are not customers of these providers. They are bona fide second-hand owners of these devices, and they get tens of thousands of phones a month, millions a year, and they get them from Best Buy, they get them from Walmart, they get them from Virgin, they get them from AT&T, they get them from CCIA, and and then walk into the AT&T or the Sprint store and say, will you unlock this for me, I'm not a customer. That just simply isn't what's happening here. And just to give you some sense of the scale of this in terms of the interest, Virgin has 5 million customers. Verizon has about 80 million customers. AT&T, I believe, has a comparable number, and AT&T and Verizon together are about 60% of the wireless market. The recycling industry estimates that about 2/3 of those phones are replaced every year, and that the average lifespan of a phone is about 18 months. So if you look just at Verizon, they are needing to recycle or reuse about 54 million phones just from that one carrier every year. So there is a huge gap between Virgin and the rest of the industry, and a huge gap between what recycling is currently being done and what could and should be done. And for some more information about the recycling issue, I gave you the year-end report from 2008 from the cellular, so that you can see a bit about the kinds of programs they have, the volume that they're dealing with, and also the amount of phones that still are ending up in landfill. So, just one other point on that. If you look at Verizon's recycle and reuse program, Hope Line, they collect 1 million phones per year. That's 1 million out of the 54 million phones that Verizon customers probably stop using every year. There is a huge need for companies like my client, and that's because carriers simply don't fulfill the reuse recycling needs. They don't have any incentive to. There's no reason for them frankly, there's no economic incentive for them to do so. And my clients are trying to step into and fill that gap. And the reuse of these phones is greatly promoted by increasing the number of potential customers that could be on this phone. When you have a phone, you don't know what network it can be used on, and you don't know what customers will want to buy it. You can unlock that phone, and most of these phones, once unlocked, will be compatible on any CDMA or any GSM network. That greatly increases the chance that somebody somewhere will be able to get some use out of this item instead of it ending up in the landfill. So I'd like to be available to answer any questions that you have, but I also have some questions about some questions that I think that the submission from Virgin really doesn't answer about when they don't unlock, where do they think those handsets that are retired go if they don't unlock them? And they're selling new handsets to customers less than pretty much a new one every year. I wonder whether they are bringing 1201 claims in their cases or not, and why they think that they've had the growth that they have even though the exemption has existed for the past 3 years. And why some CDMA carriers do unlock if they're saying that that's so closely tied to the copyright infringement of the ringtones and the wallpaper and those other works. We know that they unlock, and they do so because they do so in narrow circumstances that are not adequate for the reuse and recycling reasons. But then that begs the question of why they think that this lock is required for protecting other areas.
Thank you very much. It's a pleasure to be here with several witnesses who know a great deal about this technology and about these markets. And for that reason, I'm going to try to be very brief because I don't know as much as any of them do about those questions. And we have obviously a lot of disagreement, although I'm not sure how many of them are directly relevant to the task that's before you. What I would just like to add on behalf of the joint commenters is to say, first of all, we're not either supporting or opposing in principle an exemption in this area. It depends on whether the proponents meet their burden of showing meeting the statutory standards for exemption. But I did want to just bring to your attention a couple of areas where I think the record is quite different this year than require you to have some inquiries that you handle this a little bit differently than 3 years ago. And a lot of this actually derives from Exhibit A to the NPRM comments that the EFF put in the second round, which provide a more detailed explanation of some of what's going on here in the act of circumvention. Back in 2006, if you look at page 51 of the recommendation, he basically concluded that there's nothing in the record that has any suggestion that there's any infringement involved, and nothing that can't reasonably be understood as infringement what people are doing as a result of circumvention. Now, without regard to whether that characterization of the 2006 record, 2009 record seems to me is pretty different. There certainly is a suggestion of infringement, and we heard that from Virgin Mobile and some of the other papers. And on this issue, I think last time, my recollection is that the reason you reached that conclusion may have been because a lot of what was going on was what Jennifer Granick just described, which was entering new values into databases that, and the question was whether that was the creation of a derivative work or was that something else, just like inputting the FinCo into the APM, or the example you gave. And this is, if you look at the submission from Cricket, they make the same argument. This argument is made by several of the proponents. But if you look at Exhibit A, on page 13, it seems really clear that what is happening here is installing a patched version of Apple's baseband firmware, as the Apple example is giving. And this is about unlocking, not jailbreaking, if you will. This is about access to the network. And it states that this is basically identical to Apple's code, except, and then there are some differences. So it seems pretty clearly to make the case that a derivative work is being prepared or adaptation is being prepared. So the Section 117 issues that Ms. Granick just talked about are quite relevant here. I'm not going to get into the merits of the argument one way or another, but as I read the 2006 decision, you didn't even reach that. You didn't even touch 117 because there was not, in your view, any evidence in the record that there was any adaptation being made. That's not the case now. There certainly is evidence of it, obviously, for you to decide how credible that evidence is. But I think the 117 issues may have to be joined. And the second area where I think the record is quite different is on this question of access to works other than the firmware that controls access to the network. In your decision, your recommendation in 2006, you reviewed the evidence and you said, really, it's just speculation that there might be some access to these other works. As I recall, we said on behalf of the joint commenters, this could happen, and there was some evidence that no, it probably wouldn't happen because of the structure of where DRM would come in, digital rights management would come in, and your conclusion was that our concern was really speculative, and therefore it was not really a factor in your decision. But again, I think if you look at Exhibit A on page 13, you find what I thought was interesting was that exactly the same tool that is used to circumvent access controls leading to applications is also used to circumvent the access controls with regard to network access. It's this PWNAGE tool, and I think it's in Welsh that has W as a vowel, so I don't know how to pronounce that, but it's the same tool. And it strikes me if the same tool is being used in the same way to achieve one objective, maybe it's not just a speculative issue. And of course, you also heard testimony from Virgin Mobile. So this is obviously, again, it's just pointing out that there's another area in the record. And you said on page 53, of the recommendation, quite properly, I think, that you want to make sure to avoid any unintended consequences of this. We now have a record that I think is a little more than speculation about whether there would be this impact. And so I think you have to take that into account. Let me just conclude by mentioning 3 areas where we looked at the proposals from 5B, C, and D and had some concerns about the wording. And then there is now this joint proposal, but if I'm not mistaken, maybe I don't think your clients have signed on to that proposal. I'm not sure of the status of that, but the other 2 proposals did. So, first of all, for the reasons I just stated, I think it is very important to retain this language about the sole purpose the access to the other network. Because again, there's some evidence that it would accomplish access to a lot of other things, and that obviously is a very great concern to the joint commenters, the music industry, and others, the video game industry, and others whose content we're talking about, to some extent. I think we would also recommend, as we do in our general list of limiting factors on page 8 of our submission, that this really be limited to acts of circumvention that solely have the effect of enabling access to another network, regardless of how you prove the purpose or the intent. That's always difficult, but you can sometimes look more objectively what the effect is. Second, there's been a proposal to move from language dealing with wireless telephone handsets and wireless telephone communications network to more capacious language about wireless communications devices, wireless communications networks. I think I understand the motivation for this, but I think you have to look very carefully again what might be the unintended consequences of this. If you look at the Metro PCS submission, we're talking about wireless broadband cards that might be used in a laptop, might be a component of a video game console that would qualify as a wireless communications device. Perhaps the whole console would qualify as a wireless communications device. Perhaps every computer which is capable of gaining access to a wireless network would be considered a wireless communications device. So we're concerned about the breadth of this. We don't know also whether the factual issues that will be debated here about telephones really apply in that context. For example, how common is it that a wireless broadband card used in connection with one of these devices will only allow access to one particular network? I know, fortunately, the one in my laptop accesses all kinds of networks. So, again, I don't know, there may be a factual question, but certainly the factual case that's being made here may not be the same in that environment. And we also would have different behaviors as far as switching costs. There's a lot of discussion about whether people would actually swap out their phones more quickly anyway before the subscription period is over. It might be totally different if you're talking about a much wider range of wireless communications devices, laptops, video game consoles, and everything else. So you can't just assume that the same conditions would apply there. So you have to, again, look at the commercial behavior. And finally, the commercial purpose issue, and I see that the other proponents dropped that phrasing. I said they didn't feel they needed that phrasing. If I recall correctly, in the exemption, I gathered that wireless alliance and others still want to have that phrasing in the exemption, regardless of commercial purpose.
Or that you made clear that just because there's some financial aspect to it doesn't mean that it's not solely for connecting to a network.
Well, I see our concern about soul is a little bit different because it's about what else it does rather than why you're doing it. But I think it is important to note, as some of the submissions have said, that really many of the proponents of these, not all, many of the proponents are entities that are offering circumvention services to consumers, and I think that has to be taken into account. So I just wanted to add those brief observations about the state of the record that I think are important for the copyright office to look at, and I'd be glad at this point to refer to people that are more expert than I am on some of the cases.
Okay, I'm going to turn back to Virgin Mobile. Let's see, do you want to add anything based on what you've heard?
Sure, I'd like to respond to Ms. Grannick's questions for Virgin Mobile. First, with respect to recycling, the idea that our company is doing anything to inhibit recycling, specifically by cellular, is preposterous. In fact, the first deal that we did after we signed a supply agreement or purchase agreement with a handset manufacturer was to go to Recellular and sign a recycling agreement with Recellular. And here's what we asked them to do, and they do this. They take our trademark off the phone. We give them, they reflash our phones, so they take all the copyrighted content off, and they take the operating system off. They then, for whatever they have the right to do, whatever software they have the right to put on the phone, and they wouldn't do that if they're recycling the phone and breaking it down, or they can resell it to someone who wants to use it. That's the proper business model. for reseller. That's in fact what they do. And nothing that we do inhibits that model. And as I said, we were the first carrier to offer prepaid pouches or like packages. We actually, we're very involved with teen homelessness in the country. November is National Teen Homelessness Month because we've lobbied Congress, and one thing we do is we distribute refurbished handsets for teen homeless youth, or a million homeless teenagers in the country, which is also outrageous, but they also have, they have to know this is their best way of communicating, communications device. So we've been at the forefront of recycling efforts in the industry, and the copyright, the protections we put on the phone to protect copyright and to protect the use of the phone do not in any way inhibit recycling. Second, we've got to discuss wonder why we've enjoyed such growth despite the exemption. In fact, when the exemption, we didn't have the opportunity, of course, to participate or proceed it. When the exemption was granted, we were hit with a rash of bulk buying that decimated our earnings for the year. They, even had we made money 10 years, it would have exceeded our earnings for the year. What happened was that people went out, they bought 10 handsets at Walmart, 10 handsets at Target. They cleaned out the stores of our handsets so legitimate consumers couldn't buy our handsets. They reflashed them and they shipped them overseas. And they pocketed the subsidies that we invested. They violated an array of rights. It was an expense of $40 or $50 million for us. We then had to increase our investment in the software security of the phone. At that point, we recovered our footing and enjoyed the growth. If that were to happen again, and these bulk purchasers could rely on this exemption, which is what they would like to do, as Inspiratic proposes it, this could happen at any time. It's simply a matter of, it's a race. It's like an arms race where we are trying to improve the software security faster than the unlocking software that gets released every month. And we're totally vulnerable, primarily because of this exemption. Ms. Bragg distributed this, asked why some carriers will unlock. Well, clearly, a more sophisticated handset that has a chipset that can support separate DRM, where you can unlock the phone for the purpose of the network without risking the copyrighted material, carriers are free to do that. We're not. We may be, there may be different circumstances, but other carriers, as I said, they sell with a 2-year contract. You can subsidize a very, very sophisticated handset fully. You can offer it for free, and you can unlock it because you're assured of your revenue, and then because the DRM is separate from the handset security, you can be assured of the copyrighted content will remain protected. This handout really is completely unrelated to Virgin Mobile in the U.S. Virgin Group is a federation of companies. We write to the Virgin brand, they're a shareholder. They're not a controlling share, they have a minority stake in the company. This is for a GSM, for the GSM network. The GSM business model, as it exists overseas, is very, very different. Because almost all the carriers in the market will use GSM, the handsets are sold generally separate from the service. So there's no, the entire model is different. And this is actually what you have to do, in fact, to activate the phone with a Virgin Mobile Australia service to begin with. And it's really, I think this is totally inapplicable to what we're discussing here. I think that is the, let's see if there's anything else that we can thank you.
Okay, thank you. You want to say anything else?
Yes, thank you. First of all, the problem with bulk purchase and resale predated the 2006 exemption. Virgin had lawsuits against bulk purchasers and resellers before the 2006 exemption, as did TracFone. So it was not the exemption that caused the problem. The problem is caused by the fact that they sell their handsets with a huge subsidy, and people find that if they can technologically unlock those handsets, they can sell them for more. That's their business model, and that's what the problem is caused by. Now, if they have a higher quality TTM that's more expensive to break, that eats into the profit that the bulk purchasers can obtain. But it is not and so they find it useful to, in practicing that business model, to invest money in the CPM. But that is not the result of the 2006 exemption. So my question to Virgin was whether or not they raised 1201 as a claim in their lawsuit against the bulk purchasers. And I don't think we got an answer to that.
We do not, because of this exemption, we couldn't. But I will say that.
Okay, but you can respond maybe to, I mean, TrackBone raises the 1201 claim in their cases against bulk resellers.
Because of the exemption, we had stronger arguments. We had stronger claims in trademark and contract. After the exemption, we would have much stronger claims against the bulk purchasers. But this entire proceeding is in fact about a business model, because in this granted law, there's no question that there's unlocking the handset as the proponents want to do is not about accessing copyrighted content for legitimate business, for fair use. It is not about the copyrighted material law. It is simply about a business model that allows people to free ride on the investment that other companies make. That is what is at stake here. It's not a copyright issue at all. Second, Ms. Beck discussed section 117. 117 does not apply. 117 requires that the owner of a copy of the computer program allows them to make a copy of that copy an essential step in the utilization of that program. And the country report said that essential step has to be one that's necessary to enable the use for which it was both sold and purchased. So here, making a copy is not an essential step for legitimate use of the program. It's very clearly an illegitimate use and an unlawful use of the program. So 117 is clearly inapplicable here. It doesn't provide any protection. It doesn't support that argument.
Let me ask you about that.
But may I, I'm sorry.
One moment. I'm going to get something out of the first place you said. You have filed lawsuits, you've not made allegations for the section 1201. What do you think? Trademark allegations, what else?
Because of the exemption, we focus on the use of the trademark. Because what happens is that our handset, it says Virgin Mobile. Again, we're not a manufacturer of handsets. We offer a service. We offer the Virgin Mobile service. It says Virgin Mobile on it. It has our logo on it. It was sold with enforceable terms of purchase, just like many. It's very clear. It's written in very clear, large letters, and it's easy to understand. And our customers certainly understand it. And in fact, it's not our customers who are seeking to reflash our phones. It's free riders who are seeking to reflash our phones. And what happens is the handset with the Virgin Mobile trademark gets used on another network, and then it doesn't work, and the consumer, there's a fair amount of confusion about whose phone it is. Why it doesn't work because it's never designed for use with that other service. Or it doesn't work as well as it should, certainly. So we make an array of contract and trademark claims.
Okay, and where's your track record?
We haven't lost the case yet, but the exemption has substantially weakened. I believe it's
How does it even get lost the case? Why is it even relevant? Why is the exemption even relevant? If you've pursued these other claims, apparently you've been successful with them.
Well, in fact, Metro PCS has now sued us. They sued us a couple of months ago, saying they wanted a declaratory judgment that the exemption specifically permits the use.
Who cares?
Well, we certainly care.
Hold on. If you were asserting trademark claims and contract claims, you're succeeding on them, why does it matter whether you got 1201 claims as well? It's surplus, isn't it?
Yeah. As I said, Metro PCS is suing us, arguing that the exemption permits reflashing of our handset.
So it could
We haven't sued them, but that case hasn't been
decided.
decided. I should say, actually, I'm sorry. The fact that we did well in the array of suits that years ago. Most recently, Metro PCS, in the lawsuit, the day launched against Virgin Mobile, seeking a declaratory judgment that the exemption at issue here permits reflashing. So it is very much at the heart of the matter.
So are you the exemption preempts your trademark and contract claims?
those are separate claims. I mean, that's what we've asserted as a county, but that case hasn't been decided.
You've got separate claims that are viable regardless of the exemption. Isn't that true?
Ideally, we'd be adjudicating the case, but we don't know. We don't know how we're doing it in that case. It hasn't been decided.
So you're afraid that a court might conclude this exemption somehow vitiates your claim for trademark and contract claims?
Absolutely. And that is exactly what
Do you take that
seriously. We certainly take it seriously. It's a critical lawsuit for us. Metro PCS certainly takes it seriously. Those are the claims that they're asserting. I appreciate the confidence in our position. I wish I shared the confidence, but we're certainly hopeful.
Okay. This is what the question was then.
May I just have,
Yeah,
Pete,
I did
I
interrupt.
asked him a question and then,
Okay,
and then
sure.
he kind of took over and I took, just if you don't mind, just a few
No.
more. And I do, so I will be very brief. The claim is that bulk unlocking is a problem. And they have trademark and copyright claims against bulk unlockers. The issue is when the customer wants to go to a Metro PCS and wants to sell the phone to somebody else, can they unlock their phone and use that phone on a different network? And this is not infringing. Infringing depends upon the idea that that's somehow a contract violation to make it infringing. But as I said, and as I think everybody accepts, that this is changing a value in the registry. It's not a modification of the binary in the vast majority of cases. Now, Mr. Medalist pointed out some technology specific to the iPhone. I think we're going to talk a lot more about the iPhone later on this afternoon, so I'm not going to say too much about that. But that is a 117, that adaptation, so you can use the firmware of the phone on a different network, would be protected by 117. I don't even think that adaptation occurs in most of the cases because all you're doing is changing the lock value, whether it be the SPC lock or the SIM lock. That's all you're doing, and that allows you to change other data variables so that you can use the phone on the network. There's no adaptation, there's no copying, there's no infringement, there's nothing. And to the extent that there is, as I said, I believe that it's covered by 117 and Kraft versus Title Firm, which allows people to make those adaptations even when the original seller doesn't like the use that the owner is making of them. That's why we have the 117, right? So in terms of the question of there being access to works other than the firmware, we're just talking about a circumvention for the purpose of accessing that firmware so that you can connect it to another network. It's not clear to me from the testimony today how unlocking the phone so that it can go on another network and you can change something like the preferred roaming list gives you the ability or some kind of newfound ability to do any kind of infringement. But what is clear to me is that in the vast majority of cases with providers who have a much greater market share than Virgin, they don't have that concern because they unlock their phones sometimes voluntarily. And then just one comment about Mr. Medalist's point about the sole purpose. We agree with the idea that the purpose should be to access the network, just that companies like mine that unlock phones, or customers who unlock phones and also maybe are reselling those phones or want to save money or something like that, that financial part of the transaction doesn't mean that they don't enjoy the benefit of the exemption. What I think is merely just clarifying something about the 2006 exemption as opposed to making something different. And I think that the limitation of saying it's not, changing the exemption because it's not about the purpose of the exemption is to connect lawfully to another wireless network, but that is the sole effect. Again, I would point out that the average consumer cannot know prior to the unlocking whether removing that lock or zeroing it out is going to allow access to other content on the phone. The customer's not even asking that. They just want to know, what do I need to do to take my phone from one network to another network? So that's why I think that the exemption needs to be created in terms of the user's purpose and activities as opposed to what the technological effect of that unlocking might be.
Could I just add one point on that? I mean, then that's a question of who should bear the risk of the consumer's ignorance, and I don't see why the copyright owner should bear the risk that the consumers don't know, may not know, may find out later that, again, if this testimony is credited, that this whole, all of these ringtones and all of these, all this wallpaper and so forth in games is accessible in a way that it wasn't prior to the circumvention. If that's the case, then I think, I don't think it's unreasonable to craft the exemption in the way that
So I just have one comment on the technical aspect of this. Most CDMA phones, as soon as you enter the SBC or the MSL, which is actually the same thing, and you try to reflash it, work in the way that's actually described in the Cricket testimony on page 7, it's updating the preferred roaming list and the memory locations of the phone. Right? So you will absolutely have access to all of the calculated works. Here.
Can I follow up that because one thing that wasn't clear to me? I heard one statement that reflashing is rid of the software. Is that right? It's rid of the software?
Not necessarily.
Okay.
So there are two methods for a binary reflash. One that will completely wipe out all of the binary code on the embedded on the memory. There are also reflashing methods that actually keep the content in the embedded file system. So if you bought a game before or ringtone before, you can reflash it with a new binary and keep the old ringtones and forward.
Okay, so at least one form of reflashing would basically wipe out everything on the phone.
Yes, that's one method.
Okay, Ben?
So I have a number of questions. The first, I'll direct you to the board. Are you a member of CPIA?
We are an associate member of CPIA.
I was just wondering because they have submitted an exemption request and concur, and I was wondering what you thought about that.
We are filing separately because we don't agree on that.
Okay.
But we didn't resign from the organization in protest.
Tell me, you heard about eBay today. Have you read eBay's comments? You find comments?
I have not had the opportunity.
There was an interesting argument that I heard. Yeah, I'm not sure if you know what their opinion is.
We'll respond in the written response to those. Let's look at it. Appreciate the opportunity to do that.
Now, as we've heard also, there was new narrow and careless language proposed by the proponents. Do you have anything to add with regards to that new language that we have supporting that?
We do not at this time. Again, we'll submit a written response and review of it.
Now, for Jennifer, what are your views on early termination fees? In other words, if the request is granted as you want, is it also true in those respects that consumers have to pay the carrier for proceeding the contract early? They won't need to run the carrier.
Yes, those contractual remedies that the carrier has would remain intact.
So in other words, if they're bound by the contract and we're good with it, and once they get done with that, and go on and where they want to go.
Yes, the contract terms remain, and nothing about this is, and I think there might be a little bit of a kind of misapprehension, nothing about this is saying that the carrier cannot hold customers to contracts. And I'm not even saying that carriers are now hereby obligated to unlock phones for their customers, just that customers or owners of the phone can unlock for themselves. And if I choose to go to a different carrier and breach my contract, then I am liable for those contract remedies just the same as I would be normally.
That would be a disincentive to some.
I think it's a huge disincentive, and I think it's the appropriate disincentive, because that contract remedies are where the parties decide what the economic relationship is worth to them. And the problem with the DMCA applicability is that there are statutory remedies that are separate from that, and also potential criminal penalties. And that adds a entirely different level of disincentive that is that could very well be excessive for given what the economic relationship is. And that is one of the reasons why maybe carriers like it, but it is one of the reasons why it's not appropriate for this market.
Now, there's also other people remedies, right? There could be someone bringing antitrust suit or state trade suit as well.
In terms of remedies for the users?
For the users, exactly.
Yes, and I think that the filing of the Public Interest Spectrum Coalition says that there are other things, other policies, and perhaps other changes in telecommunications law that might be necessary to really bring United States policy into a situation where there really is a very open and vibrant market for these types of services, but this is certainly not that. This is simply one small aspect of giving customers that kind of choice.
Well, speaking of the FCC, I know that they recently opened for comment a proceeding petition for rulemaking filed by the Rural Cellular Association. Are you familiar with that at all?
Is it the Carter phone for wireless?
Yeah, I mean,
yes, I'm mildly familiar.
I'll read this record. The Rural Cellular Association requests that the Commission initiate the rulemaking to investigate the widespread use of anti-competitive effects of exclusive arrangements between commercial wireless carriers and handset manufacturers, and as necessary, adopt rules to prohibit such arrangements when contrary to public interest, consistent with its obligation under the DMCA. So my question to you is, so if the Commission goes down that road, this is at the very first stages, does that somehow do any exemption in the chance, or is it complementary to what you're looking for?
I think that the exemption needs space for that agency to make those kinds of rules. I think that basically this is clearing the way for that agency to make the decisions about wireless competitiveness that are appropriate given its jurisdiction and its purview, and that they make those decisions. That's something that they do a lot of the time, and I do think it's needed. I mean, just as an example, when AT&T took over Singular and absorbed all the Singular customers, AT&T would not let the Singular customers unlock their Singular phones to put them on the AT&T network. They just simply refused to do so because they saw the merger as an opportunity for them to sell new phones to the millions of Singular people. And it may very well be that that this is contrary to United States policy, and that we should have rules and regulations that prohibit that kind of thing. And I think that in the meanwhile, we shouldn't have rules that constrain those Singular customers from exercising some kind of self-help and unlocking those phones and then getting them on an AT&T network or leaving and going to a different network.
Let's think about other factors that we can consider. I read recently that in France, the French Competition Council had asked to negotiate the exclusive agreement between Orange and Apple. I was wondering if that's something that we consider as another factor, another government response in relation to the same question.
I think that is another factor, and I think it's hard to give an exclusive list of what other factors might be, but competition policy being formulated by other United States agencies and by other governments is certainly something I think the Copyright Office is well entitled to consider when deciding what the scope and purview of copyright regulation ought to be.
One last question. Is it possible, if we granted this as a new question, that I could take my phone and use Skype and then avoid any kind of wireless charges altogether? So in other words, I can take my phone, install my phone, and then I'll take the service ever again.
This exemption for unlocking to use on another network would not do that in and of itself. You would first of all have to have a phone that could run the Skype application on it, which many of these DMCA phones are talking about, and other phones doesn't. But the iPhone, and that this exemption in combination, or even just the jailbreaking exemption alone, which would allow you to run applications on a phone that's capable of running those applications. In that case, I think granting that exemption would allow customers to put Skype on their phone and use wireless, put Firefox on their phone and avoid the Safari browser, put a different mail client on their phone and avoid using Apple Mail, and all of those things. This exemption, in the way that it's phrased, I think is alone would not accomplish that.
Okay, this question came up and then Walter Oscar was calling the law concerned about using the iPad with Skype. That was a big thing. I don't know how many more people start buying iPads rather than iPhones, but you can get communication going between you and your friends and family.
Yes, and I think the iPad has that capability.
Well, thanks. That's all the questions I have.
Thank you.
Okay, thank you. Dave?
First of all, I think I misheard something you said, but I want to make sure. At one point, did you say that your clients purchased some of those retail stores like Best Buy and Walmart?
My clients are partners with Best Buy in their recycling efforts.
Oh, okay, I see, okay. Now, we've heard, this is a question for anyone, we've heard about the problem of some people who actually do go to Best Buy and Walmart to scoop up the cheap phones that the country are going to block for sale, and then strip them of what's on them and resell them. Assuming that's a problem that is a consequence of the existing exemptions that we'd like to avoid, and some things it's one we shouldn't want to avoid, that's what you tell us. But assuming it is something we'd like to avoid, anyone have any ideas on how, if we were inclined to continue exemptions along the lines of what we already have, we could pass it in such a way that it would not include that kind of conduct?
What you could do is you could allow an exemption, and you did something in writing, clarifying it, but for legitimate customers who previously used the service for which the device was intended, to themselves request the phone. If they needed to go to some type of other store to do so, that might be something, but it has to be a consumer who has previously used that service for some sufficient period of time that the carrier, in our case, will allow us to recover our investment. Once that consumer has used the phone in a way that is clear, our whatever it might be, we haven't specified one, but allowed us to recover our investment, then that customer might be able to do that. But again, that's just not what's happening. What's happening is that bulk purchasers, Metro PCS also, is taking to say, go buy a phone, don't ever use it for the purpose for which it was intended, and we flash it with this other purpose. And that's in fact what's happening here. I also, if that's a satisfactory answer, I would like to just address a couple of other issues that I think may be clouding the view. I think the idea that we're a reactionary, anti-open technology company, I think is inaccurate. We view ourselves as one of the most entrepreneurial and innovative companies in the wireless space. The discussion about open networks that accompany the new spectrum that the FCC is considering opening, we don't have a problem with that. We think open networks, someone should run an open network, and people should sell open devices. What we object to is forcing us to sell open devices. Again, open networks, that may be an excellent model, and there may be a great business in selling unlocked devices. We just haven't been able to make it work and don't want to be forced to do so. Also, the discussion about carbon phone and the exclusivity arrangements, we don't have a strong view about that either. If whether a carrier and a handset maker, we won't wade into it, frankly, but we think that that's a separate issue in terms of exclusive arrangements between a wireless provider and a manufacturer. We think they can be useful. We think they can create marketing opportunities to drive down prices, but again, not an absolutely critical issue for us. So again, open networks, the Carter phone proceedings, you mentioned Orange and the Apple, none of those really, even the use of Skype on a network, there will be a time when people will pay data charges for the use of Skype rather than voice charges, for example, for the use of minutes. And if the handset is Wi-Fi enabled, they may not use a cellular network. Again, we think those are separate issues than what's at stake here. And we're not offering a view, we're not saying we're categorically against any of those developments at all.
Let me go back to your response to my question. I'm wondering whether that response means that the dramatic response is that they will take advantage of the investment. If the answer is yes, I'd like you to react to that.
I'm sorry, I didn't follow.
Okay. As I understand it, your response to that question is how might we refashion this exemption in a way that prevents the bulk purchasers of class resellers from going to Walmart and just cleaning them out and then reselling them, was limit the exemption, I think, to people who have actually purchased and used the phone for some period of time. I gather that would mean that the grant clients would not be able to take advantage of the exemption. Is that correct?
I'm not sure. I mean, we were worried about bulk purchases to which our trademark claims, for example, that we put the program they were strongest. But we're also very much concerned about companies like Metro PCS who are encouraging, we'll say, buy this handset, we repurpose it, never use it for the purpose for which it was intended. And that's not necessarily a bulk purchase scheme. That is totally reliant on this exemption. And so I think what we need to do is allow customers who have used the phone legitimately for a period of time that's acceptable to the seller as well. And say, now if you want to take it with you and you've used it for a period of time, then that would, and I'm sure in terms of her clients, I mean, I don't see how it would be a problem for the seller. I don't believe the seller, I'm not sure I understand the seller's issue actually. We look forward to reading the detail we need to do for them.
Well, let me ask Brad, do you understand what we just suggested? Does that work for you?
No, because my clients are not customers of these providers, and my clients haven't previously used these phones. My customers get phones from a variety of sources. One of those sources is Virgin, but frankly, the amount of phones that Virgin provides to my customers or to my clients is a fraction of the total number of phones that my clients process in a year. And it's an even tinier fraction of the total number of phones that are eligible or qualified for reuse and recycling each year in the United States. So we need an exemption that allows us to get a phone from a church or a school or from a user that just sends it in exchange for a credit or for as a contribution to Cell Phones for Soldiers or any of the other charities that Recellular or my other clients run, and not have to determine whether it's been activated before and on what network, but we can just refurbish that phone and make it available on the secondhand market. And that's the only thing that's economically feasible that keeps the recycling companies as a feasible business.
Can you come up with any way that would allow your clients to continue to do what they're doing without also bulk purchasers / resellers around doing what they're doing?
Well, first of all, I think that the bulk purchase is a concern, and it's a concern I'm very sympathetic about. I've written about the concern that, in particular, TracFone has with the bulk purchasers, and that I understand the position they're coming from. I don't think that it's a copyright concern. I think it's a business model concern. I think it's a trademark concern. I think it's a contract concern and an unfair competition concern, but I don't think it's a copyright concern. But I have spoken with the lawyer for TracFone, who does their bulk lawsuits, Jim Baldinger. We became friendly after he deposed me in one of his lawsuits where the defendant listed me as an expert in the case. And Jim thought it would be...
That's the way to make friends, right?
You know, lawyers are weird people, and that's how we get to know each other. And he and I, to be frank, before this rulemaking, we talked about that issue of whether there was some idea we had, and you know, maybe more intelligent people than me can come up with. If the office thinks that this is a copyright concern and wants to address it, maybe you can come up with something that I couldn't come up with something that helps people like my clients who get a phone in the mail, or more accurately, get tens of thousands or millions of phones in the mail, something that works for them. And I couldn't come up with a solution to that problem.
It's possible that we could help in this process, but I think coming up with an exemption that walks that line. But I think we're really getting into the other point here, which is picks up on the whole question of the other factors that you can take into account. I think it's important to, again, look back at the statute from time to time. And the other factors only enter in to your determination of whether a non-infringing use is being competed, paraphrasing here, but it's not necessarily a warrant for all the public interest
Understood.
issues.
We wouldn't even consider doing that unless it's not a case been made in the first place. But then if we had, it might be appropriate to try to make sure we're.
Absolutely. I mean, obviously, there's no way this isn't hermetically sealed from all these other issues, and perhaps there is some way to do it that would help us satisfy.
Now, I'm pretty technologically literate in this area, but I want to follow up on the question I asked earlier about the reflashing. I gather there's at least in some circumstances a way to deal with this by reflashing, which basically wipes everything off your phone. My first question is, if that's all you were allowed to do, would that serve your purpose?
No, I don't, it would not, because for customers, most directly, for customers who want to unlock their own phones and use them on a different network, they have their music or ringtones, the manufacturer operating system that they're a legitimate licensee of, and the phone is designed to work on a different network. All they want, instead of getting rid of all of that stuff, all they want to do is change this one parameter so that they can go on a different network. Same thing with a GSM phone. I may love my phone here in the United States and want to maintain my relationship with my carrier, but I'm going overseas to travel for a month. And I don't want to reflash my phone or get rid of everything. I just want to unlock it so I can put a different SIM card in it so that while I'm in Europe, I can use it there, and when I come back, I will continue my contractual relationship with my regular provider. So that would not resolve the problem.
Steve, you may or may not be in a position to speak to the copyright owner whose content, as Brandon just mentioned, she's speaking about might want to take with them. But with your clients who own that content, who are the copyright owners of that content, ringtone, maybe audio music or whatever, would they have a problem with someone who decided to leave Virgin Mobile or Tractor or whatever and take their phone to some other carrier? Would they have a problem with that person taking the ringtone or whatever it is with them? You're not having a problem. That's only the first question. You also have explaining why they would think they have a legitimate right to complain.
Yeah, I think I'm going to have to get back to you on some of that, but my concern would be not so much, can you continue to use that ringtone on your phone on the new network, because presumably whatever the deal was between the copyright owner and the original network would kind of cover that. But my concern is this exhibit, the embedded file system view, and whether this facilitates other uses of that were not contemplated at the time when the content was behind the access control, and it could be used to generate the ringtone, but not necessarily to send to 50 of your friends or using other purposes. That's where I think the concern will lie. I don't know the answer as to whether how much this increases the likelihood of that, but that's the reason why we think that the record this time actually has a little bit more. There's a little bit more to it, perhaps, for you to look at as far as the impact is going to be. I think on the reflashing question, I think we did talk about this 3 years ago. There's a footnote in the recommendation to suggest that if all you're doing is wiping out the what's on there, it's not even an act of circumvention. By the way, we raised this argument 3 years ago in some of the rootkit context, and we did not actually see fit to engage us on that or make a decision on that. But we still think if you're eliminating something, if you're eliminating the content, eliminating the copyrighted material, then it's hard to see how that's actually an act of circumvention if you haven't gained access to anything that you otherwise have. The problem is, as I understand it from the description in Exhibit A, what happens in the reflash of the Apple setting anyway is, they wipe out everything and then they put in a patched version which is identical except for allowing access to things where access wasn't allowed before. So the problem is that derivative work is being created and an adaptation is being created, and then we get into whether or not that's an infringing.
Is there a consensus that everyone agrees the kind of reflash we've been talking about does not involve circumvention? Or is there anything it does?
About wiping out the entire.
Yeah. And that's circumvention of access control. You're getting rid of it. You're getting rid of what's connected as well.
Well, but we've been I would use this more thought, because I think that you've invested in this, you've loaded copyrighted content and software on the device for a specific purpose. If you're wiping it out, then we sold it to no benefit. Right? I mean, that's,
You got
other than that,
price for it.
I'm sorry?
You got price for it, whether benefiting is accepting it from.
We're expecting customers to use it with our service.
Okay, your operating system and your software. Okay, I'm really thinking about the, Let's move on to that then. I think if I heard you correctly, you said that while it's possible to have more sophisticated access controls that might separately protect your operating system firmware on the one hand, and then separately protect things like ringtones and audiovisual content and so on, then that is not feasible with your business model. Is that a fair characterization of what you said? Mm-hmm. Okay. So basically, you're stuck with having this security software that protects everything. You can't discriminate. Is that the notion? You have the technological ability, with the software you have, to put the part of the firmware or whatever it is that controls access to the telephone network on the other side of the security software. In other words, could you choose, I know why you wouldn't choose, but could you choose to have that security software protect all the copyrighted content and in fact protect everything except what a person would need to get to in order to say, I want to switch from Virgin Mobile to some other network?
So in perpetuity, no, because we don't know what other attack methods might be developed in the future to, create a fence now between the copyrighted works and executable code. We don't know how good that fence is going to be a year from now or 2 years from now, and so forth. From our perspective, it's much easier to have one very, very strong protection mechanism that protects everything than to try to spread it out. Also, if we start to develop different protection mechanisms by content type, which is all, it's hard to predict, whether certain content types that might be more desirable, such as games, would become really the focus of attacks, the brute force attacks to crack that protection mechanism.
Are you the only company that does this? Or are there any companies that also protect everything they want?
So typically, DMCA rule-based devices, that print work in exactly the same way.
But you obviously don't protect everything at once. In other words, if I get a cell phone from you, there's certain information I can put into that cell phone, and your security software isn't going to prevent me from doing that. Why is it that your security software necessarily has to prevent me from punching in a new code so I can connect to another network? Why does it have to work that way? In other words, if you chose not to protect that ability, if you chose not to basically force me to stay on your network as long as I use that code, what is it technically, if anything, that prevents you from letting me do that?
So there's also some hardware-based limitations based on the value tier chipset that we use that are not capable.
Okay, I sort of understand what you're saying, but you haven't given me enough information to evaluate what you're saying.
So typically the chipsets that we use are in a different class than what you might get on an Apple iPhone. So they're very low-end, inexpensive chipsets that simply do not have any kind of secure file or DRM mechanism.
Well, I'm not sure if what I'm about to say is responsive to what you said, because I'm not sure I entirely understand what you said. But I guess what I'm saying is, if you chose not to make that secure, if you chose not to secure the ability to switch to another network, if you wanted to choose, would you be constrained from exercising that choice by the technology you're using?
It's going to be an engineering problem. If we put enough engineers in it, we could probably resolve it over time. But it's a cost of the chip and the cost of the engineering effort. So the rate don't have an economic impact on our business.
So we buy chips at a certain price. And those chips are less sophisticated than maybe the ones that Verizon uses, and they're more sophisticated devices that they offer with their sophisticated customers. And we have to buy more expensive chips. Handset prices will rise, and that's not our customer segment.
How much more expensive?
Actually, I'm not sure, but,
Double or more.
Pardon?
Double or more.
Double or price of the chip.
Yeah.
Well, what's the price of the chip right now?
It depends. Yeah, between.
it might be,
Yeah, it might be confidential information actually.
Are we talking single digits, double digits? Or?
Double digits.
Brad, if you have any more light to share, any questions I've asked you?
Yeah, just to point out, for example, Verizon doesn't lock its handsets. Verizon no longer locks its handsets. Yet Verizon disables certain functionality, like Bluetooth and Verizon protected content. So there's nothing special about network locking that relates it necessarily in any way to content protection. And it is, I still haven't heard anything, and that's the way it is for the vast majority of phones. I think that there may be some technological differences with the iPhone, which you'll talk about later, and I can't compare to Steve's presume to be an expert on what Virgin's engineering is, but I don't see any reason why they can't allow the customer to change the preferred roaming list and the few other variables that are required to connect a CDMA phone to another CDMA network, and yet have their master subscriber lock control access to the file system that they showed in their demonstration. It is what other CDMA and GSM providers do.
I think what's happening is there's a failure to understand that there are customers who can't afford it, and that Verizon offers sophisticated unlocked devices with 2-year contracts that is heavily subsidized that are completely different than what we're talking about. You're saying, yes, the Mercedes has 16 airbags, but the Kia has 2. And if you want us to put 16 airbags, the customer might be safer, but it's a different car, and the customer would be bicycling because they can't afford that car. That's really what we're talking about here. The other part of it is, getting back, I've been thinking about where we might reach a compromise. And the idea that the recyclers don't know where the handsets are coming from is highly unlikely. They do know where the handsets are coming from, and they know in good faith whether they're coming from people who have reflashed the phones, whether they're coming from bins where legitimate customers are depositing them. And something like a strong good faith requirement might be a solution to some of these various clients, because they do know. They know when they're getting handsets from us. They know when they're getting handsets from a bin at a Best Buy store. They know where they're coming from. The origin is never, I would say, very unclear. And they know what to do with the handset to comply with all requirements.
Well, how do we evaluate that? Because Grant tells us they don't. And we're here saying, you say they can, he says they can't, and we're here saying, how do we?
We routinely get inquiries from people saying, there's a shipment out there, I'd like to buy it, and we know where those handsets are. Handsets are very traceable. They all have security identifiers. We know exactly where we shipped it the first time, where it ended up, who bought it. It's not, there's no mystery actually when they get a handset where it came from.
And if one of her clients told you, I've got the following 500 handsets, can you please let me know whether they're legitimate or not, and you had to let them know?
I think what's actually occurring is that you're trying to enable a free rider speed, and they know that those handsets are coming from maybe a company that is encouraging customers not to repurpose handsets for a network which is not intended, and they're getting the handsets from that carrier, and so they know how old the handsets are, when they were sold, they know that it's highly unlikely they were ever used. For example, the Virgin Mobile service, it was a 8-month-old handset, and it came from a network that actively encourages customers to buy phones and repurpose them for use which they're not intended. And then they get recycled, they get sent to recycler. They know that those handsets were never used properly. It's not, they're experts, it's not a mystery.
Okay, let's get to what this is all about. It's about central control and it's about technological measures that control access to copyrighted works. Now, my question for the most part is going to talk about protecting access to copyrighted works. Thus far, it focuses more on the copyrighted works owned by Mr. McCallum, who you might characterize as innocent bystanders in this whole thing. They didn't put the technological measures on, but because some of them will be done for appropriate purposes, there's some maybe exposed. Let's focus on Virgin Mobile's copyright issues here, because I'm not quite sure I know what it is. So if you can tell me what copyright is Virgin Mobile is being protected by your technological measures, that would help me understand the basis for your opposition to this exemption much more than I do right now.
We sell, for example, ringtones that we buy and license from a music company. And we are required to protect those ringtones and make them not freely tradable or copyable. These companies have all kinds of problems with piracy, and they don't want piracy a problem in the mobile space. If the handset security is compromised, the security of the ringtone is compromised. And will we be in violation of the agreement? Because we know, see again, it's not a mystery to us, we know that the handsets are purpose. We know, for example, if customers were, we know when we sell 10,000 handsets and they don't get activated on our network, people aren't using them as paperweights. They're getting repurposed. We know that that's happening. And then you would know, you would have to go tell the content owners that, hey, you don't know that content, it's open, you can't protect it. That's one part of the copyright interest, the legitimate copyright interest that we're trying to protect.
Okay, is there any of your own copyright work
Yes.
that is being protected by it?
Yes. The user interface we developed, we also preload ringtones that we compose, graphics that we design, we have copyright interest, and when the security software is compromised, those are open, and they can be copied.
We also have applications that we wrote internally that run on the handset, like the address book backup application.
Okay, and obviously you've got a record where a lot of people have gone ahead and cracked through this stuff and resold phones together. Are you aware of any cases where there has been, in fact, illicit copying of that content and perhaps redistribution to other people, apart from just the use of the copy on that particular handset?
I'm not, but we haven't.
No, it's reported out, it's nothing else.
I'm not aware of specific widespread trading other than but it's certainly possible.
Is there any reason why you have to trade on this?
Well, we don't want to sell, we like to sell a product that's attractive, and when you turn it on, it has a ringtone that someone likes to listen to without having to buy another one.
Well, having service with Virgin? I mean, once you connected to Virgin service for the first time, couldn't you?
So could we, I think, if the question is, could we put an over-the-air configuration of the phone where we download over the air? And we were talking about that earlier. I think you said it would cost $6 million every time you did it. So the answer is we could, but that's a different business model that our customers can't afford.
Is it your assertion?
I'm not even quite sure we could, but it seems possible.
Is it your position that when someone does crack through the security measures and takes the cell phone and uses it with another network and continues to use your user interface or your ringtones or whatever, that they're agreeing with the copy?
They are. They also are they infringing?
Again, I'm trying to figure out what copyright you have here. And so far, I don't know what copyright you have. I know that there are third parties copyright investigations allocated to that. I'm trying to figure out yours.
Okay, there are ringtones, for example. There are graphics, some of which are designed by third parties. The graphics, the wallpaper, like the pictures you put on the phone. Some of which we design, some of which are third party licensed, like we license third parties. But just taking the ones that we design, we sell it, we invest in that copyrighted content, we sell it. The consumer doesn't use it with our service. They are infringing on our copyrighted.
We have exclusive rights to infringing on our that.
So they're not using the content for the purpose of this intended.
And when you hear exclusive rights under Section 106 of Title 17 of the U.S. Code are being infringed, when a customer takes that handset, switches to another service, and uses the user interface, listens to the ringtone, whatever.
I'd like to respond to this.
Good idea.
Could I just, I don't know the situation with Virgin Mobile, but in general, when you have a license, covers use of copyright materials, reproduction rights, in the case of software, and your use of it is in violation of that.
I might be expecting to hear him talk about a license, but I haven't so far.
Well, I don't want the record to show that if there's a use in violation of the license, that wouldn't necessarily.
I can conceive those cases, but I'm trying to be told what they actually are in the real world, as opposed to what I might imagine. All right,
Well, just picking up with your point with the back question about the licenses, I have a couple questions about your reply comment or responsive comment related to those licenses. First of all, is it your position that this quote-unquote terms of purchase agreement is a binding contract?
Yes. The terms of purchase, we use the term terms of purchase to refer to the handset packaging, and the terms of service, which are, and that's just a short statement that says it's for use of our foreign to operate.
And the difference between those two, the terms of purchase is something that is just on the packaging. It doesn't have anything to do with any service, but in order to own that piece of hardware, no matter what you are doing with it, you're saying you're using this language of this phone is sold exclusively for use with service with Virgin Mobile provides commercial resale prohibited except by authorized agent of the U.S. dealers. You may not alter any of the hardware. So that all of that language is imposed on the purchaser just by purchasing that physical item.
I think it's a sentence maybe too, but yeah, it simply says that the handset is for use with our service. Again, we don't manufacture the handset, we provide a service. And that's what it's for.
Well, then I'm confused because you also have the term service agreement, and you say that Virgin Mobile customers who activate their handset with Virgin Mobile also agree to the terms of service. And then you go on to say that the terms of service constitute a binding contract. Well, that seems to suggest to me that wasn't referenced in the first part, and I actually have questions about that in terms of the binding nature of the purchase of the device. I can understand the binding contract once you connect with the service and click through or agree to that. In relation to that, I guess one of the things that I wanted to address was that your way of limiting this exemption was that the user, it would have to be someone who had used your service before. Now that creates the problem of once you use the service, then you do have a binding contract, and all of those terms of that contract then live with that customer forever after in relation to that. So doesn't that create sort of a catch-22? If you force someone on the basis of a limitation to actually connect with your service and use it, then all of a sudden all of the licensing restrictions that you may impose in that terms of service then become binding on the user.
Okay. One is simply a shrink wrap design package, because if you're buying the handset, you intend to use it, you must use it with our service. That's the purpose of the product. And you can't alter it. Once you've activated the service, at that point you have an opportunity to read more detailed terms, and that's what I think the difference is. We want to put those kind of terms on.
Isn't that the same kind of? I mean, I seem to remember another terms of purchase agreement like that was placed inside of a book a long time ago, and the court in that situation found that you could not just impose based on purchase.
That's exactly where we go. The terms of purchase are very simple, and I think if you cite, you intend to use with our product. When you activate the service, you're in a position to your education about the service increases. Our terms of service are mostly involved with how the service offers work, and the pricing, and what you charge. And at that point, when you activate the service, you're agreeing to those terms. I don't see any consistency. I think we're simply trying to make it very clear to the consumer that on the package, this is intended for use to build a product. I just wouldn't put a more complicated service agreement on the package.
Jennifer, do you see any problem in terms of those different contractual terms?
I think I briefly mentioned that I have real questions about the enforceability, about the formation and the enforceability of contract as a result of this. I mean, I think that if you look at the case law, and the cases aren't coming to mind right now, but there are cases that say that there's a real difference between box top or package terms and click-through licenses where the purchaser has the requirement of making a manifestation of intent. And so these terms that are, I'm not clear whether they're on the box or in the box or what the situation is, but there's no manifestation of intent. And I think that you have a purchase agreement that says when you purchased it, you agreed. There's some real question of whether that is, and I think under the case law, there's a real question of whether that actually is a legitimate contract formation. And then also, aside from feeling like, aside from my thought that that's not a real contract, and also looking at the terms of service, it's not clear to me that the language in the terms of service that a user might click through tells the user that they can't use the phone on another service. What this says to me is you can't use the service with another phone. And that is different. That's, you cannot use our service with any other phone or device or on any other network. Maybe that means you can't use the service on any other network. I don't know what that means. But I do have some real questions about this being a legitimate contract, and one sort of dragoons the person into something that they're not fully aware of and haven't really intended to.
Well, do you think, with this aversion too, do you think that when a consumer pays whatever the cost is of the phone, that they believe and you having a different view, that the customer then owns that phone?
Because we do that, the 117 customer is not the owner of the software. They have a license to it. I'm having a hard time correlating two different aspects of this session. On the one hand, we're being told that as long as we've got contract rights, why are we worried about exemption? And on the other hand, you're saying that contract's no good anyway. Actually, it's a very simple terms of purchase. That's never been an issue for us. It's written, it's one sentence, it might be two, and the terms of service in the agreement are not written in a lawyerly fashion. I know because I wrote them, and they're written in a very conversational way. And the enforceability of those terms, I hope, is not an issue because we clearly don't have an exact. We can't rely on the DMCA to protect.
Those contractual terms would never apply to third parties who didn't have any relationship with those contractual terms. So when David was asking questions about what other remedies, we're talking about trademark, other kinds of remedies outside of contract. There's no privity between other parties who may end up with this device to these particular contract provisions. So that was never the issue in those particular cases. But getting to the question, leaving aside the question of the analysis then of whether this is. And well, let me ask Jennifer, actually, just your view of, you think that a purchaser of that phone has a reasonable expectation of ownership of that device?
I think the purchaser is an owner, and the purchaser has the rights that are associated with the control that owners have. There is no requirement to return the device. There's perpetual possession. They may throw the device away. There's no limitation or continued relationship, persistent relationship between the licensor or the seller and the purchaser. And if you look at perhaps the title serve and the kind of rights that the person had, or that the purchaser had there, or those are that's the language. So if you just pardon me for a second, and I can read what the case says. So this is Kraus is the case talking about what owner rights are under 117, and it is not whether or not a license comes along with the product or not, but what the nature of the rights associated with the purchase are. And in Kraus, the court says it's anomalous for a user whose degree of ownership of a copy is so complete that he may lawfully use it and keep it forever, or is so inclined to dispose of it, throw it in the trash, to nonetheless be unauthorized to modify it under 117. And this is the situation of the cell phone owner.
We agree with Kraus, but that's not what the case holds. In Kraus, the customer, it was customized software that the customer needed to change for it to be used for its intended purpose. They paid substantial consideration. That's not an issue.
Well, that's what I'm going to get to, because you make in these response comments make the point that 117A1 entitled the owner of the computer, copy of the computer program is to make or authorize making of another copy or adaptation, provided that such a new copy or adaptation is created as an essential step in the utilization of the computer program. And then the argument is made in relation to the Cantu report that the key criteria is for an essential step is whether the copy or adaptation was necessary to enable the use for which it was both sold and purchased. Now, the question I have there, and was highlighted in the comments, is the purpose for which it is sold. Now, you can go to different levels of abstractions, I guess, and get to the point of what the purpose is and what, in specific, for Virgin may have had additional purposes. But it isn't, in a general sense, the purpose for which this computer program is sold and purchased is to operate the phone.
We respectfully disagree. We are not a device manufacturer. Our phones bear two logos. One is Virgin Mobile for the service, and one is generally the logo of the manufacturer. The purpose for which we sell the device is for use with the Virgin Mobile service. It is not an essential step. 117. It is not an essential step to make a copy to repurpose the device for use on another network. That's not an essential step.
It is an essential step to adapt it, to put it to another network, all right?
But that's not the purpose.
That's not your purpose, but it's purpose, maybe the purpose for which the consumer bought the phone.
And that's why we, in bold letters on the phone, we say the purpose of the phone is for use of the Virgin Mobile service.
Just one other thing. I know we're running into our time for the next panel, and maybe some other questions, but
there are open handsets that consumers can buy that are sold by manufacturers. If a consumer wants to buy an open handset and use it and activate it, they have every right to do so. We think that's wonderful. We don't have any problem with it. What we object to is being forced to increase the cost of our handset for consumers who can't afford it. And I still disagree that there's a copyright interest in the proponent's case because they're trying to defend a business model, not the interest of the copyrighted content.
Well, that's what we're trying to get to as well. The Virgin is to what extent discussing on business model choice and actually involving copyrighted work. In relation to the copyrighted work that are there, and we're sort of operating in blind here because I know that there are certain maybe trade secret information and other in which will prevent you from exposing some of the prices of the chipset and some of these other factors, but it makes it hard for us to evaluate then what the additional cost is for different ways of doing things to evaluate to what extent this business model is necessary to serve these lowest income or whatever the people who are desire this phone as opposed to others. But one of the main points that we need to clarify, I think, is in relation to some of the questions David was raising and whether these can be the copyrighted work that may be contained on the phone or other ones that may be downloaded onto the phone. Is there any reason why these have to be, aside from business model interests, costs, concerns that you're trying to achieve, why these have to be protected in a bundled form? And could the master subscriber lock that's placed on there in terms of getting access to the network be protected in one bundle and then have a protection for all the other potential copyrights? Is it possible to do that?
If you bought more expensive handset that had more expensive chips on the order of double the magnitude, again, we operate on margins of dollars. We negotiate every last, literally penny on a handset, on the per unit handset cost. So a change of $20 in a handset price on a per unit basis is dramatic
Is that how much the change would cost?
No, we're talking about, we just got to a point where we said double digits, and it would be double that, so that's, even at the lowest point. But I really can't talk about chipset costs, and I can't talk about the wholesale cost in handset.
Well, you just have to understand that we can't make it hard for us to evaluate them.
My point is that if it's double, and it's in double digits, and the lowest change might be $20, that is a dramatic difference for business that negotiates handset prices by the penny. And so the answer is we could buy more expensive handsets with more expensive chips and distinguish the DRM from the network box. But that's a different product.
Yes, you do.
Yes.
I understand what the thrust of this question, but I think there would be a concern with conditioning the degree of protection for technological protection measure on how expensive it is, and saying that the Cadillac is protected, the Kia is not, because of Cadillac. And I can understand that it's certainly a factor to take into account because obviously technological protection measures may work in different ways and they may have different impacts as far as how they impede non-infringing use. So that's certainly legitimate, but I think Congress was pretty clear, again, resisted a number of efforts to say, well, your technological protection measure has to meet this certain standard. It has to be effective, but that's not a really demanding standard in terms of how robust it has to be. Let's put that there, how distributed.
Well, we are operating in a situation where we had an exemption 3 years ago. I think the testimony was that you had to change your system in order to have more robust DRM in order to protect it in light of that exemption. And in doing so, then you chose to do it in such a way that the only way that someone could move the phone to another provider, they would have to expose the copyrighted content as well that's contained within that phone. So you created the environment in which, while you may have contractual provisions to protect that, you're doing it in a way that seemed to have, if another exemption were to go forward, would necessarily expose that.
I can say that none of there was never a conversation between the engineering team, the developed Exterior, and the legal team that is examining the exemption to develop security software that somehow got around the exemption. That never happened. That conversation never took place. What drove it? No, but I think that's what the implication is, right? That we're somehow putting everything in one closet so we can make a clean argument before the U.S. Copyright Office. That's not the case. What's driving it is the technological capacity of the chipset and the cost of that chipset.
Okay, we are 55 minutes behind schedule. I'm going to let Ben ask the final question.
This is just a follow-up. We're talking about SIM cards, right? So I read an article from the Register for the United Kingdom on April 24th. T-Mobile USA has announced plans to use a limited SIM system device to make use of the GSM network, preventing hunters from using them on other networks by switching to SIM. I was just wondering if you know about this and what you're feeling about that.
I don't know about it. I'm not familiar with what that technological protection measure might be, that where you would be unable to take a SIM out and put another SIM in. I know that many GSM phones are locked to a particular SIM card, and that you can unlock them and put in any other SIM card. But this particular situation, I don't know.
You would like that ability to do that.
Yes, and I think that these phone companies have a lot of reasons why they want to do it. They may want to lock people in to avoid bulk resellers. They have legal remedies against that. They may want to lock people in because they don't want other companies, like a competitor, to get their customer to buy a subsidized handset and then move over without ever buying any kind of service. They have remedies against that in terms of competition law and inducing breach of contract. But that means the vast majority, multiple times, a company with 5 million users versus an industry where we have, I don't know how many, at least 125 million cell phones that are retired every year. And it leaves open the question of what those owners and the recyclers who want to do something productive with those phones can do.
It does appear that you still have some questions, so we would may well be submitting some questions to you after this. We are going to, because we've been here for quite a while, take a 15-minute break. And so in 15 minutes we will okay. Okay, we're starting with you. And I think the person who follows is Greg. And then we're going to David, and then we're going to Stephen, and then we're ending up with Sean. Is that okay with everybody? All right. It's all yours, Greg.
Thank you very much. My name is Greg Joswick. People call me Jaws. If you hear David or somebody refer to me as that, you know who they're talking about. I'm the Vice President of iPod and iPhone product marketing. And maybe to give you just a little snippet of what that means at Apple, product marketing is we're the folks that work with our executive team and our engineers on the products we're going to create, the decisions we're going to make about those products, the price points, feature sets, etc. I'm responsible for the iPod and iPhone business. And of course, as such, I have a very senior role in the App Store, and the App Store creation and the policies that we created. So today, just to give you a bit of an overview of what all we discussed, and of course, being an Apple guy, I'm going to use slides. I want to talk about, first of all, of course, what we've created with the iPhone and the App Store. We've created a revolutionary mobile platform and ecosystem. We've unleashed unprecedented creative development with the apps in the App Store. And the iPhone is at the heart of this entire ecosystem. And jailbreaking hacks and modifies the OS. And by doing such, infringes upon Apple and third-party software. And this destabilizes what is otherwise a vastly beneficial ecosystem. That's because when you modify and hack the iPhone OS, anything can go wrong. So first of all, the iPhone, as a bit of background, is a revolutionary device. It's been, of course, a revolution in the aspects of being a great phone, a great iPod, and it puts the internet in your pocket. And it's a phone that appeals to regular people by allowing them to use the device without having to be very technical, and allowing them to do things they never dreamed they could do on a phone before. And this is a product that our customers love. In fact, we were just awarded the J.D. Power Award for the phone with the highest customer satisfaction. I was just awarded this week. And that goes along with the award we got from J.D. Power last year for the phone with the highest customer satisfaction in business. So indeed, it is the phone that has forever changed all phones in lots of different ways. And one of those ways is the App Store. And the App Store provides a safe and reliable way for our customers to extend the capability of the iPhone, and has become a key part of the iPhone experience. It is in and of itself a revolution. It provides a revolutionary way for developers to create and then distribute applications, and of course allowing our customers to do things with their mobile device that have never dreamed they could, and again has changed the industry. As a piece of history, this all started a little over a year ago, in March of 2008. That's when we first launched our software development kit for the iPhone OS. And the iPhone OS, it's worth adding, is the operating system that controls both the iPhone and the iPod Touch. And this software development kit contains the same APIs and tools that Apple uses to create our applications for the iPhone and the iPod Touch. In July of this past year, so in the summer, July 11th to be specific, we launched the App Store, a revolutionary marketplace for developers to distribute the apps that they were able to create with our revolutionary tools and APIs. And this had a very innovative business model that existed for our developers. One is they get to pick the price. And 70% of that price goes directly back to the developer. And out of the remaining 30%, we cover all other costs. So to the developer, there's no credit card fees, there's no hosting fees, there's no marketing fees, and of course we run the store out of the remaining dollars that are left as well. And free apps remain free. We wanted to have a provision so that if developers wanted to deliver applications free to their to our customers, that Apple would bear all the cost of that. There'd be no cost whatsoever for either developers or customers. So again, the App Store has been quite the revolution. So we want to create a superb experience for our customers with the App Store. And as such, there are certain things that we don't think belong within the App Store. We think that a lot of them make a lot of common sense. We didn't want to have porn up there. We didn't want to have illegal apps that could violate a customer's privacy, etc., or bugging apps, even for that matter. The good news is that 96% of the apps that are submitted are approved in our most recent data. And as a matter of fact, we've gotten faster than ever in approving those apps. Full 98% of those apps are actually now approved within 1 week. And we've allowed our developers, for the very first time on any mobile platform, to reach every customer. And that's because the App Store exists on the device. It exists on the iPhone, it exists on the iPod Touch. Every single device we sell has that App Store, and that then gives developers access to every customer. And it has produced absolutely historic results. We have had over 800,000 downloads of our free software development kit in just the first year, from March to March. And we have over 50,000 individuals and companies in our iPhone developer program. Obviously, this number speaks for itself, that developers love what we've created. And that's further underscored by this number. In 9 months of having the App Store, there have been over 35,000 apps created and posted in that App Store. This makes it the world's largest application marketplace. And we just passed a very giant milestone. We have had our 1 billionth customer download in just 9 months. That's 1 billion downloads of copyrighted software applications through the App Store. Again, no one could have ever envisioned this when we started this less than a year ago. So the App Store, again, has been a historic and revolutionary creation. And of course, we created a revolutionary mobile experience for our customers as a result. And our competitors have been scrambling to emulate the success that we've created with the App Store. And we've removed the barriers of success for our developers. And this is probably worth adding, has worked for both little developers and big developers. It levels the playing field. Again, they all have access to every customer. And the tools that we've given them have allowed them to create very innovative apps. And as I mentioned, we provide efficient distribution to every single customer. How did this all come about? Well, Apple had a pretty groundbreaking idea, but we couldn't do it alone, quite honestly. To do it, we had to establish trust. We had to establish trust first and foremost with some of our key partners, which include the carrier partners around the world, because we were about to unleash thousands of applications on their network. And without the trust of those applications that would be running on their network would neither damage or cripple their network, this could not happen. And of course, for our developer partners, we had to create the trust with them that we would have a secure and safe place for them to have their commerce, to sell their apps, and in order for them to create a business. And of course, that trust also extended to customers, that they too would have a safe and trusted place to acquire their software. And the interactions between all these constituencies have to be protected. And we do that with the App Store. So the App Store, as I mentioned, has become a key part of the iPhone experience. Well, the entire iPhone experience, really, the heart of it is run through the iPhone operating system, the iPhone OS. In fact, the iPhone OS is at the heart of the entire iPhone ecosystem and experience. The iPhone OS controls the interactions with the App Store, the user interface, the software development kit, the developers and their business, the applications that create, obviously the functionality of the product, the interaction, as I mentioned, with the network, and the interaction with iTunes and the media that our customers own. Jailbreaking attacks that OS at its heart. And jailbreaking, another way of saying it, is hacking the iPhone. Hacking the iPhone OS. And those aren't just our words. These are their words. This is a snippet from a program recently held by the community of hackers who hacked the iPhone, and you can see how they refer to themselves. And I'm going to come back to them in just a minute. So, why do we secure the iPhone? Why do we have these security mechanisms in it? Well, one is we want to protect product from modification and copying. Protect our software from being modified and copied. Because these OS modifications can cause damage. And we want to secure the user's data. Again, their email, their contacts, their pictures, etc. And we want to defend from piracy of both Apple and third-party software. And ultimately, of course, we want to protect a very high-quality iPhone experience for our customers. So how do we do this? Well, it all starts with the secure ROM. Secure ROM is, in and of its nature, read-only. It contains a lot of information that's necessary for starting up the iPhone, for instance. It also has some hidden keys down in it. And those crypto keys, which again are buried down into the hardware, are obtained and used to validate and establish a root of trust, which then allows us to load in what's called a bootloader. A bootloader contains information necessary for initializing the hardware, and maybe even more importantly, is what validates the OS signature so that we can actually load in a qualified OS operating system. And that OS does everything to run the iPhone as well as to validate each of the apps through a signature each time that they're launched. I referred to that program a minute ago about hacking the iPhone, and I thought it's worth, provided our audio agrees with us here, we're having to deal with technical issues earlier, that maybe to hear in their own words a clip that shows a slide that they presented in their own words about what their goals are when it comes to hacking the iPhone.
So our goal here is to sort of subvert this and to, modify the operating system so that we can run our own code.
Again, that entire presentation they have, by the way, is available on the web. I believe it's actually cited, and you have the papers, so you can certainly, if you're so moved, go hear the whole thing. But I think this says it pretty clearly as to what their goals are. So how do they do it? How do they hack the iPhone and the iPhone OS? Well, the first thing they do is they trick the system so that they can bypass the validation that comes from the secure ROM, and in essence, severing that root of trust. That then enables them to load a modified bootloader. They falsely sign it, and again, the system will load it. That then gets them to what they want to do, which is to install a hacked and unqualified version of the operating system, which gets them to their end goal, which is to disable the signature validation for apps so they can run any app that they want. Well, what are the consequences of doing something like that? Well, when you hack the OS and remove all the protection, anything can happen. As I mentioned, the OS runs everything. And this allows any app, regardless of its functionality, its reliability, or even its safety, to run. And this also, which has been a big issue for our developers, allows pirated apps to run because the signatures are not checked when they're launched. As a matter of fact, there are far-reaching risks and threats and damages that can be caused when this happens. And I thought it's probably worth mentioning a few of those. Now again, I say a few of those because when you do modify the OS, anything can happen, and there are certainly things that can happen beyond what I'll describe to you today. But I'll start by giving you the risks and damages of each of the three key areas. Number one, let's start with consumers. Crashes and instability. As I mentioned, or the hacking the OS, bad things can happen. One of the things that we found is that jailbroken iPhones crash a lot. As a matter of fact, jailbroken iPhones represent far less than 1% of all iPhones out there. Yet they're responsible for the overall #1 crashing bug on the iPhone. Imagine if that was allowed to be more widespread. Malfunctioning and safety. The iPhone OS is that controls everything, including things like how quickly you can charge the battery safely, the volume control, and again, when you hack the OS, whether there are unintended consequences and there can be intentional consequences that can cause safety issues with the product. Invasion of privacy. One of the things that we check for in the App Store process is to make sure that apps aren't violating customers' privacy. For instance, stealing customer data, again, whether that's contact, email, pictures, etc. To make sure that it's not turning the camera or the microphone on without the user knowing, or even tracking the customer with the GPS. Jailbroken apps wouldn't have those kind of checks. And again, it would run a very serious risk as to violating the customer's privacy. Exposing children to age-inappropriate content. We right now reject offensive content. And we are continuing to enhance our parental controls on the product. Matter of fact, we have significantly enhanced parental controls with iPhone OS 3.0 delivering this summer. Jailbroken apps would, of course, bypass any of this process or these controls, which, again, would risk exposing children to age-inappropriate content. Viruses and malware. No one likes viruses and malware, period. You certainly don't want it on your phone. How bad would it be if you want to make a critical phone call and you were denied service on your phone because of some virus or malware that you got from downloading a software application for your phone? Inability to update the software. Again, when you hack the software, you may, in fact, make it so that we can no longer update the software because it's been damaged in some way that no longer allows it to be updated. This indeed has already happened. Let's talk about now risks and damages to our partners. As I mentioned, we never could have done this without the trust of our carrier partners around the world, and we currently work with about 30 of them. And rely and roam on, and significantly more than that. And again, unleashing thousands of applications on that network without any concern as to how they might damage, cripple that network would be a huge issue, because this network isn't just a network that iPhones use. This is a network that all phones use, regardless of who the manufacturer is. And piracy of developers' applications. As I mentioned, this has become a huge issue. What happens in the jailbroken process is, again, they can run any app without checking the signature. And what happens is there are a number of people in this community that have taken apps, they're able to strip the DRM off, they put it up on their website, and people who have jailbroken phones can then download the software without any compensation back to the developer, and the jailbroken phone will run it because there's no validation check that it's indeed a legitimately purchased app. And I speak to developers all the time. For them, this is a big issue. And although there may be others who can find exceptions, anybody who tells you that the general developer community is in favor of jailbroken phones is either misguided, misinformed, or misrepresenting the situation. Instability of developers' applications. I talked about the fact that jailbroken phones tend to be very unstable phones. And that can be reflected in crashing of legitimate developers' applications through no fault of that developer, which again can create support issues for that developer, as well as, of course, people just reflecting badly on that developer and their application. Finally, let's get to risks and damages to Apple. I said earlier that one of the ultimate goals for us is to have a great iPhone experience for our customers. You've heard some of the risks and issues I mentioned just for customers and developers. That, of course, is very detrimental to the iPhone experience. And ultimately, that's the value proposition we have for our customers, is a great experience that we've tried to create is better than anything you can get anywhere else. And of course, in hand with that, if you damage the iPhone experience, you risk damaging Apple's brand. You risk a damage that can go far beyond the effect on the iPhone and the iPod Touch. You certainly, again, can damage the goodwill and reputation that we've built up with our customers for years if they start to have a bad experience with our product. And the sad thing for people who have jailbroken phones, they don't even oftentimes realize that the problems they have trace back to having jailbroken their phone. Increased support burden. As I mentioned, jailbroken phones represent far less than 1% of the iPhones that are out there, and yet they contribute to the overall number one crashing bug, or they represent the overall number one crashing bug for iPhones. And this is when it's a small niche. Imagine if it were allowed to become widespread. Imagine what would happen as far as both customer problems and, of course, our support burden and cost would just explode. Partner relationships. Again, both the carrier relationships and the developer relationships. The effect of bad applications on the network, the effect of pirated apps from our developers are big issues. And our partners in this, through that established trust, look for us to manage the situation. And if this, again, were to become widespread, this would be very difficult relationships to manage. As a matter of fact, it would have severe limitation in our ability to innovate. We never could have achieved the App Store, the revolutionary way of distributing apps that we did without that trust from these partners. If that trust were to be eroded through allowing jailbreaking to become widespread, this would severely limit our ability to continue doing what we're doing, as well as, of course, innovating into the future. So as I mentioned, the iPhone OS is at the core of what we do. If the iPhone OS were to become compromised, then indeed every single element of the iPhone ecosystem and experience would become compromised. This would be a very, very bad thing. And that's why I would urge you to please say no to the request for the waiver, the exemption that's being requested by DFS.
Thank you very much.
Thanks very much. I know the hour is getting late. I will try to focus on the points that I think are likely to be the core disputed points, and leave a lot of the things I might talk about have already been raised in our written submissions, and I will try to leave that there. Let me just start by pointing out that I have an iPhone. I'm a big fan of Apple products and the iPhone in particular. This is not about trying to argue that point. This is also not about arguing that anyone would be forced to jailbreak their iPhone. Many of the paternalistic concerns that you have just heard, if they are accurate, then great. Many users will opt not to jailbreak their phones in light of the very concerns that have just been highlighted for you. No doubt Apple and its many partners can further highlight those concerns in the market. No one is talking about foisting jailbreaking on unwilling or uninformed consumers. I will point out, moreover, that we have heard arguments like this from incumbents in other contexts many times. Those who are familiar with the telecommunications history, a lot of this should remind you of the old pre-Carter phone debates, when AT&T told you that consumers shouldn't be allowed to have any equipment in their homes because it would compromise the network. It might, in AT&T's words, electrocute customers if shoddy equipment were used. Again, it turns out that wasn't the case once competition emerged. Similarly, my auto manufacturer, I have a Toyota. Toyota would, of course, prefer that I use nothing but authentic Toyota parts and Toyota dealers for service. And they would also prefer I not modify my Toyota in ways that might be dangerous to me. I appreciate all that, but it is my automobile at the end of the day, and we haven't in other contexts opted for a different legal regime other than free market competition and consumer choice. In 2006, the librarian on the recommendation, the Copyright Office grants an exemption for phone unlocking. We just obviously heard quite a bit about it. In that recommendation, the Copyright Office pointed out that, quote, when application of the prohibition on circumvention of access controls would offer no apparent benefit to the author or copyright owner in relation to the work to which access is controlled, but simply offers a benefit to a third party who may use Section 1201 to control the use of hardware, which as is increasingly the case, may be operated in part through the use of computer software or firmware, an exemption may well be warranted. It's our view that this is exactly in that wheelhouse. So the question here is whether, of course, as you know, the prohibition has or is likely to have a substantial adverse effect on non-infringing users. Not whether it might undermine consumer experience for those who unwisely choose to jailbreak and perhaps regret their choice. Not other business model concerns, many of which were just discussed. Let me give you a few additional facts that I think may be helpful. Contrary to the testimony you just heard, our facts submitted in the record suggest that there are at least 1.8 million jailbroken iPhones currently out there, constituting roughly 10% of iPhones in release. These are numbers that have been submitted by Jay Freeman, who runs the leading independent app store called Cydia. In his submission, he said 1.6 million iPhones. I have sent correspondence with him just earlier this week to ask for updated numbers. He says just in those few months, based on his numbers, it's at least 1.8 million iPhones, of which roughly 400,000 appear to be located in the United States. Again, he gets these numbers because when someone jailbreaks an iPhone, generally one of the pieces of software that they install is this alternative app store, an alternative marketplace for applications, again known as Cydia. There continue to be apps that are excluded. That's obviously not news. We pointed out several applications that have been excluded in our comments. Of course, we have now the report of Mozilla and Skype, who have talked about why their applications either have been excluded. In the case of Mozilla, Apple does not permit alternate browser frameworks on the iPhone. And in the case of Skype, they now have an application in the App Store, but it is not allowed to use the 3G data network in order to place calls. That is also a limitation imposed by Apple. Some of you may have seen in February the television show South Park had its application rejected from the App Store because apparently it was deemed too racy for the App Store. I am not saying that Apple should be forced to carry applications in its own application store that it finds objectionable. No more than I would suggest that Best Buy should be forced to carry products it doesn't want to carry. That's not the point. The point is that in the case of Best Buy, as a consumer, I can go across the street if I want to find an application, a product that Best Buy doesn't carry. That's what we're talking about here. Not forcing Apple to carry Mozilla, not forcing Apple to carry South Park, not forcing Apple to carry the Baby Shake application that created such a controversy just last week, but rather allowing customers to have those apps if others would like to make them available. So let me give you one other example that I discovered since we submitted our last written submission. This is an example that is on a blog called Egopoly that was brought to my attention by another independent app developer. And here, the title of it is iPhone Ringtones, SMS Alert, and Positions. Quote, I'd like to buy an iPhone for my wife. She has a Razor, and it's such junk. She doesn't get very much email, so the simple iPhone email app would be great for her to get her email and check her voicemail. But there is one huge hurdle that's blocking it. It's a big problem, and it's extremely frustrating because it could be solved so simply. It's really just a tiny little thing, and it sucks that it's stopping me from buying that shiny, shiny new phone. My wife is a physician, and part of that means being on call. What happens is this. Patients call the office at 2 in the morning, they leave a message, and the phone system sends an SMS message to her phone. Currently, it's her Razor. So I set up her Razor to have the longest, loudest possible SMS alert sound. It's important because if she happens to be at home and her phone is in the kitchen and she's in the other room, you want to hear it. So she can call you back and prescribe your meds.
But if she does happen to be way down at the other end of the house and the kids are yelling and she doesn't hear the loud long alert, the razor has a persistent page. So 5 minutes later, when she's back near the phone, she'll hear a little beep. Then she'll know she has a page and she can return it. The iPhone fails this use case in 2 ways. First, the selection of tones is pathetic. Apple has decided that there are only 10 or so sounds that are suitable for an SMS alert, and they are all quiet and short little dings and beeps. Second, there is no persistence. The iPhone won't beep every 5 minutes until you at least look at the screen and see the message indicator. I even bought a custom ringtone in the hope that it would be selectable as an SMS alert. No dice. Wasted 99 cents. I don't see how any physician can use an iPhone as their sole device. Apple has basically forced all of them to also carry a pager or Razor or BlackBerry. Why? I don't get it. And it continues, and in the comments it's pointed out that there are jailbreak applications for jailbroken phones that cure this very problem. That's just one example of an enormous array of applications that consumers want. Now, don't get me wrong. I think the 35,000 applications in the App Store are great. It's an enormous selection. But there are a variety that are not there because app developers are unable to write them. They're not there because Apple's own arbitrary terms prevent them from being there, either because they find them objectionable, or in the cases that we point out in our comments, they duplicate functionality, quote unquote. In other words, Apple would prefer to have that functionality to itself, or because they use APIs that Apple reserves solely for its own code, but no one else. There are many reasons, many kinds of apps that we're not getting. And again, I'll refer you to many that are referred to in our comments. Now, in addition, the iPhone is not all we're talking about here. The Google Android T-Mobile G1 phone has similar restrictions, and in fact, it's come to our attention that one great set of applications that is impossible to put on the G1 phone without a similar jailbreak is enabling multi-touch. The same squeeze, pinch, drag that is common on the iPhone can be enabled on the G1, but only if you jailbreak that phone, presumably in part because of T-Mobile's concerns about Apple's set of patents on that technology. But whatever the patent rationale might be, there's clearly no copyright reason why multi-touch couldn't be enabled other than the restrictions imposed in the store and on the G1 phone. So, let me turn to the legal aspects that I think have been disputed here very quickly. First, it's undisputed that the iPhone is protected by an access control subject to 1201. Obviously, we have general agreement on that point. I will note that the joint commenters suggested that 1201F may deal with this. I think that's flatly incorrect. When an individual end user jailbreaks a phone, they are not identifying and analyzing those elements of the program that are necessary for interoperability. I do think 1201F may apply to the iPhone dev team, the so-called hackers that Apple mentioned. They, of course, are doing exactly that. But I think there's no way in which a person who is jailbreaking their own phone in order to run an application of their choice could be deemed to be identifying and analyzing elements of the software. So I don't think 1201F addresses this area. Even if it did, I don't believe that the existence of a statutory exemption in the neighborhood of what we're talking about should disqualify the Copyright Office from considering something else. This is what I would call the congressional infallibility principle, that somehow in 1998 Congress knew everything there was to know about these questions. I believe the rulemaking is there specifically to allow the Copyright Office to say, you know, Congress didn't think about this thing back then. It now appears clear, and we can grant the exemption. But in any event, I don't think 1201 will apply. So it seems to me the core legal dispute we're going to have here is whether jailbreaking is non-infringing. Let me run through quickly. We can follow this up in questions if you have additional questions that I don't answer here. I have 3 answers to that. First of all, there's no reason to think that all jailbreaking will necessarily create a derivative work in the first place. I think the pwnage tool, which we mentioned in our comments, that is currently the most common and popular jailbreaking tool available, is free, as these things so often are, and
can easily be downloaded. I will concede that that does create a modified version of the firmware. It in fact does so in order to do exactly the process that was just described and that we described in more detail in Exhibit A. They essentially, because the boot ROM does not do a signature check before loading the initial bootloader component, they basically go in there and have a altered bootloader in that position. The boot ROM then loads. And once you have an altered bootloader, as the slides show, you can load altered versions of the operating system itself. It does not do signature checking, and that's the key to getting applications of your choice to run. So that is a derivative work, or at least plausibly is a derivative work. But let's not make the mistake of assuming that's the only jailbreaking mechanism, or that that will be the exclusive jailbreaking mechanism for the next 3 years. So it is easily possible that future jailbreaking technologies could run by running separate code, and injecting different code into memory while it's running. And in fact, I say this because that's exactly how the unlocking of the iPhone works currently for these latest model Apple 3G iPhones. By in fact, rather than modifying Apple's baseband code, it instead runs a separate piece of code, essentially beside it, that injects changes values in memory as the code is running. And I would submit there is no derivative work there, just as we were discussing in the last panel. But, so let's take for a moment at least the popular extant jailbreak code. Let's say it does create a derivative work, or at least arguably a derivative work. If that's the case, then I think that's expressly covered by Section 117A. There's no contention. In fact, Apple's comments do not argue that iPhone owners do not own the code within the meaning of 117. That they appear to concede that point. If they hadn't conceded it, I would have pointed out that their own license agreement says you own the media on which the software is delivered, which is, I think, the definition of owner of a copy that is laid out in 117. But in any event, it's not contested there. So what Apple does say is, one, the 117 privilege can be negated by contract. I don't agree with that. Apple, in a footnote, admits that there's no case law to support that proposition. They cite the Cantu report. I've read the Cantu report. As I'm sure you all know, the entirety of the discussion of this provision is contained on page 13 of the Cantu report. It's not terribly illuminating. Nothing therein suggests that contracts can strip users of their 117 privilege. Perhaps more to the point, there is nothing in the Apple contract that would appear to do that. In fact, I'm a bit confused about how a contract would strip you of your 117 privilege, other than to say something like, you are hereby licensed to use the code on the condition that you waive any 117 or other privilege you might have under existing law. I've never seen a license agreement say that. And certainly the iPhone software license agreement, which is publicly available if you want to read it, doesn't say anything like that. So I don't think we have a contractual negation of 117 here. Secondly, Apple suggests that the adaptations must be created by the user rather than by third party. Fine. If that's the case, still no problem here. That's exactly how the Pwnage tool operates. The iPhone dev team that created, again, this most popular jailbreaking tool, built the tool very specifically so that it does not contain any Apple code, period, modified or otherwise, not in there. Every user, when they jailbreak their phone, uses the Pwnage tool to, on their own machine, compile their own altered version of the code. So in other words, it is precisely the user that is making the adaptation, just like 117A envisioned. And finally, I guess there are two other arguments Apple makes in their papers. First, it says that adaptations may not harm the copyright owner. And that is taken again from the Cantu report. And if you look at the Cantu report, the gloss in the report there really focuses on the private nature of the use of any adaptations made under 117. There, clearly, Cantu envisions that if you make an adaptation of piece of software, you are not entitled to then redistribute it, go out in the market, and compete with the copyright owner. That's the kind of harm to the copyright owner that Cantu was concerned about, and frankly, that cases like Krauss versus TitleServe have carried forward. Not harm to a business model that the copyright owner might have in which this is a component, but rather harm in the sense of the adaptation must remain a private use. And of course, again, that's exactly what we have here. When you've jailbroken your phone, there's nothing about the process that requires or even encourages you to distribute the resulting adaptation. You put it on your phone, that's the end of the story. Finally, the Apple submission suggests that 117A requires that the adaptation must be used in no other manner, or the copy, quote, as an essential step in the utilization of the computer program in conjunction with a machine, and that it is used in no other manner. Absolutely, there is nothing in the case law that suggests that what we're talking about when a user jailbreaks their own phone uses the code in any other manner than to run that machine. Perhaps the running of that code results in your ability to then run other software, but that's not Apple's code. That's not running it in the firmware in a different manner. That's getting third-party software. So I would again point the court to Krauss versus TitleServe, where in that case the Second Circuit specifically said not only was using the software all right for the defendant, TitleServe in that case, but in fact the defendant extended that software to allow dial-up access to their mainframe. And the court found that too was all right. So the idea here is the code being used to run the machine and in no other manner? That's exactly what the resulting adapted Apple firmware is being used for here. Finally, I'll say that I also believe that to the extent it's not covered by 117, it would be covered by fair use. I'll not review that. Obviously, you all know the 4 factors. We've laid out the argument in our papers. I don't have anything new to contribute on that here. The statutory factors, again, I think they are largely neutral, just as they were in 2006 with respect to the unlocking exemption. I would point out that there's certainly no harm on the market for the firmware, as Apple itself in its written submission points out, they do not view the firmware as being a separate product at all. They view the firmware as being a necessary constituent part of the hardware device. And there's certainly nothing about jailbreaking that makes the hardware less attractive. In fact, if anything, jailbreaking makes the hardware more attractive, at least to that small segment of users who have, like the user who has a physician as a wife, for whom the jailbreak actually makes the phone more valuable. Again, if a user decides that they jailbroke and they regret it, they obviously can return to the original software if they so choose. So finally, a couple of last points. First, nothing about granting this exemption will deprive Apple of any other legal or market lever that they might have to protect their business model. Obviously, they can, if they believe that they can have some contractual claims, as we heard in the last panel. There's nothing about the exemption that would strip them of any of their other legal rights that they could use to protect their business model. Apple is certainly not the first company, and the iPhone is certainly not the first product that has tried to build a closed ecosystem as a business model. It's been done before. I'm sure it will be done again. The point here is I don't believe Congress meant when they passed the DMCA to somehow make the fact that you use firmware in your device take you out of the traditional legal world of building closed ecosystems and put you into a new box where suddenly new rules apply. In fact, the case law, such as the Chamberlain case and the Lexmark case, and the Copyright Office's recommendation in 2006 regarding unlocking, all underscore that point over and over again. Let me briefly address the problem of application piracy, something that Apple has raised here. That is certainly cause for concern, but I need to emphasize the applications are protected by separate technological protection measures. The apps, at least the ones you pay for, this is not true of the free apps, but the paid applications are separately encrypted and have separate keys that are tied to the particular phone in question.
the iPhone couldn't be more different than the Virgin mobile phones that you were talking about just a few hours ago. We are not talking about a phone that is so primitive or a chipset that is so cheap that you cannot run multiple different technological protection measures on it. In fact, Apple does exactly that. The apps are separately protected. Now, that protection has been compromised for some applications, and that is certainly a problem. But I would submit that the fact that the lock on running other applications happens to also block certain pirated applications is really no different than a car manufacturer saying, well, the lock on the door of the car happens to protect the CDs in the glove box, and therefore it's a DMCA protection that deserves the full protection of the law. No, the fact that no applications other than those approved by Apple can be run on the iPhone is the result of Apple's desire to protect its closed ecosystem. As they mentioned, it is not the DRM scheme used to protect the apps. As I said, there is a separate scheme for that. And finally, I think you'll hear this next week when you hear from an independent iPhone applications developer. If you're worried about security for the applications, one of the best things that could happen is a world in which individual application developers can develop their own TPMs to use to protect their own application. Something that's already happening where independent apps are at stake. Like people who sell applications, and they do sell applications, through alternate marketplaces like Cydia, are in the process of figuring out how do we do a better job protecting our apps than Apple has done for the apps in the App Store. And I think that's a healthy process. Some app developers may find other mechanisms that protect their business interests, some sort of authentication. Who knows? Let's let 1,000 flowers bloom. If there's anything we've learned in the last 10 years, security flourishes when there are lots of competitors trying to provide it, rather than one provider that everyone has to count on together. I think I'll leave it at that and leave the rest of the questions.
Thank you.
Thank you. I'm David Hayes from Finland and West, outside counsel to Apple. Can you hear me okay with this speaker? Okay. I'd like to begin with just a word about the legal landscape in which these proposed jailbreaking exemption has to be judged. Fred wants a world in which all applications can be run on the iPhone, as opposed to some of them needing to run on other phones. I understand that that's a world he would prefer for the reasons that he mentioned. You heard a lot in his remarks about competition, and he's concerned with what he believes will enhance competition. This exemption process was not designed to be a freewheeling fork for marketplace design or restructuring of business practices or debates about competition in the marketplace. It has a very narrow technical focus. Whether an access control is an issue at all, and if it is, whether it has a significant adverse effect on non-infringing uses of a particular class of works. That is what the Copyright Office is here to decide, and it's a very narrow focus. Congress established in sections 1201A and B a clear right of companies to protect their copyrighted works with technical protection measures, TPMs. And it said in the legislative history the reason it did that was to incentivize the creation and protection of works in a digital environment by allowing owners to protect them with TPMs. As Giles' presentation exemplifies, the creation of copyrighted works that's been enabled by the TPMs that protect the iPhone and its OS and its ecosystem has done exactly that. 35,000 applications in 9 months. That's a lot of creative copyrighted works that have been incentivized by the ecosystem protected by the TPMs. The fundamental rule here in the law is that TPMs are protected against circumvention unless the proponent of an exemption meets a very heavy burden to show specific harm, and even then only access controls circumvention can be exempted, not circumvention of copy controls. Now, EFF has not put forth any specific evidence of harm to meet that burden. There's a lot of talk about competition and so on. No data, for example, of which or how many third-party applications outside the App Store users would like to run on their iPhone, or whether those applications might be available to run on other phones, which is something that in every previous hearing this Copyright Office has focused on. And you have said in your decisions that it may be true that it's more inconvenient for someone to use a copyrighted work in some other way, but that is not relevant as long as that work can be used in some other way. Fred would prefer that it be used on the iPhone, but that is not something that this exemption process requires. So that's the legal landscape within which these exemptions must be judged. Now I'm going to draw on my high school speech class, and I'm going to now tell you the first fundamental rule of giving a speech. That is, tell them what you're going to tell them, then tell them, and then tell them what you just told them. So that's what I'm going to do. Here's what I'm going to tell them. I want to make 3 specific points. By the way, the second rule from the speech class was never make more than 3 points in a speech. So here we go. Only 3 points. First point, the proposed jailbreaking exemption that they are making is really an exemption for circumvention of copy controls, not just access controls. Those are prohibited by 1201B, and the Copyright Office and the librarian cannot grant exemptions to the protections of 1201B. Second point, the proposed jailbreaking exemption is an interoperability exemption, and Congress has already comprehensively legislated the boundaries of circumvention for interoperability in 1201F, and so an interoperability exemption should mean an even higher burden in this process to be granted. Third point, even if the jailbreaking exemption is deemed to be properly considered under the process of 1201A1, it has to be denied because the uses that would be allowed by the exemption are infringing. Each of these 3 things is a fundamental showstopper. So now let me elaborate on it. As a footnote, by the way, the third and final rule from high school speech class, never make a presentation without graphics and visuals. I wanted to do that. I asked Jaws if I could use his Mac. He said, nobody touches my Mac or my iPhone. So here we go. Sorry. Okay, so let me elaborate a bit on the first point. Exemptions cannot be granted for the prohibitions of Section 1201B that relate to copy controls. EFF is really asking for an exemption that would allow circumvention of copy controls under 1201B under the guise of the 1201A exemption process. For access controls. This is not permitted by the statute. EFF submission, and Fred said just now, he characterizes these TPMs solely as access controls, that there's no debate about that. Apparently on the ground that they prevent access to jailbroken applications running on the iPhone. That's an incorrect characterization of what these TPMs are. Access controls are technical measures that prevent the use of a copyrighted work in its unmodified form in which it was distributed. For example, encryption that requires a password to unlock access to a movie that the user has paid the usage fee. That's an access control. You use the work in its unmodified form once you gain access to it. The TPMs on the iPhone do more than this. Jaws' testimony makes clear that the iPhone TPMs are quintessentially copy controls. They were designed to prohibit modification of the OS. That's why he spent so much time in his slides describing to you the role that the OS plays in the iPhone and why it is the central heart of the iPhone, its functionality, its ecosystem, and the App Store. And those TPMs were put in place from the very beginning The engineers designed them into the phone from the very beginning, long before the App Store was online or the SDK was released publicly. Why? Because they were concerned with modifications to the OS, so they protected it in a way that it could not be modified. Those copy controls are protected by 1201B, and this process under 1201A1 cannot grant exemptions for copy controls protected by 1201B. Now there's really two devices here that the EFF, I believe, would like to see protected by this exemption process, both of which fall under 1201B. The first one is the Ponage tool itself and similar tools like it. If those tools cannot be distributed for end users to use, then obviously the exemption does not achieve what Fred would like to see, which is to jailbreak the iPhone. Well, and the second thing that this exemption would permit is a device to be established in the iPhone itself in the form of the modified bootloader, which is also a 1201B device. Now let me just elaborate very briefly. First, with respect to the Ponage tool itself. You heard Jaws play an example from that hackers convention. These were the authors of the Ponage tool, and they said in their own words, the tool was designed specifically to circumvent the security on the iPhone and create a modified OS. That's what they said was their purpose. So distribution of that tool is trafficking in a copy control circumvention that is prohibited by 1201B. And it cannot be exempted under 1201A1. Jaws, would you bring up that slide that you had on the jailbreak and phone? Yes. The second thing that this exemption device that would be permitted under 1201B, it's improper, is you see in the red, the bootloader. It's red because it's been modified. And that modified bootloader has only one purpose, and that's to bypass the copy controls on the OS that prevent it from being modified. 1201B says that no person shall manufacture a device whose purpose is solely or primarily to circumvent copy controls. That's what that modified bootloader in red is, and it is a violation of 1201B that cannot be exempted under 1201A1. Thank you, John. So the fact that the TPMs at issue here are there to protect against modifications is what distinguishes this requested exemption from the one that you just heard on the previous panel, and that was the subject of your 2006 decision with respect to unlocking. Those unlocking exemptions were all argued in terms of access to the software to make use of it in its unmodified form. Ms. Granick from the EFF made that point several times in her presentation, that we are not asking to modify the binary code. This is just to modify a piece of data and allow the binary code to run as it normally would run. That is not what is going on here. Jailbreaking modifies the OS. End of first point. Second point. Congress has already comprehensively addressed interoperability issues in the statutory provision, so this exemption process isn't the appropriate forum to address those issues. The EFF's proposed exemption is worded as, quote, for the sole purpose of enabling interoperability. If you look at 1201F and its legislative history, its literal language says it addresses acts, quote, necessary to achieve interoperability. Now, this reflects Congress' considered decision about interoperability issues, and so the Copyright Office needs to be extremely cautious in recommending an exemption that is in the interoperability area when Congress has already spoken. There is a high burden on anyone for an exemption. And in fact, you said in your 2006 decision that the granting of an exemption is extraordinary. It is unusual. I think the burden is even higher when Congress is spoken. Now, Fred referred to the congressional infallibility principle. I'm not arguing that just because we're in the zone, Congress is infallible and they can never do wrong. We all know better than that. However, Congress did, as a result of a very hotly contested legislative process, consider a number of exemptions that people were proposing to be written right into the statute. And some of them they wrote in, and some of them they didn't. They wrote one in for interoperability, they wrote one in for law enforcement, they wrote one in for security study, and they addressed this very carefully in several areas. So the Copyright Office needs to be very careful about acting in an area where Congress made these balanced choices. End of second. Third point. Even if this exemption is properly considered under 1201A1, it has to be denied because the proposed uses that would be enabled by the exemption are infringing. As you saw from Jaws' testimony, this tool, Ponage tool, creates an unauthorized modified version of Apple's copyrighted bootloader and the OS. Now, you heard Fred say it's possible that there are other methods coming that will work differently and will not be infringing, will not create modifications to the OS. Well, first of all, those are not before us now. The ones that they have rested their exemption on are Ponage tool and QuickPwn and some of the others that are in the marketplace, about which EFF says in its submission, page 7, and I'm quoting, decryption and modification of the iPhone firmware appears to be necessary for any jailbreak technique to succeed on a persistent basis. That's their words. Well, it looks to me like what's going to be enabled by this, in their own words, is tools that will be necessary to modify the OS. These modifications are not covered by Section 117 or the Fair Use Doctrine. I'm going to go through this briefly because our submission elaborates more, and so I'm not going to spend time to do every point. First of all, Section 117 rights, I do believe, can be negated by contract. The Cantu report, there are about 10 or 12 decisions, which we've cited in our papers, that have faced the question of whether the Cantu report is the legislative history of the DMCA. And all but one of those decisions have said either that it is the legislative history or they have looked to it to interpret the DMCA. And two of those decisions have quoted the passage on page 13 that Fred referred to in the Cantu report that says, if copyright owners are concerned about these rights to make modifications and adaptations, they can address it by contract. I think it's pretty clear that Cantu had in mind that you could take this right away. Fred says he doesn't know how you would do it. It's very simple. Apple has done it. In their iFirm license agreement, it says it prohibits modification of the software. How else would you say it? We want to prohibit modification for any purpose, not just for Section 117 purposes, not just because you want to do something else with it. It's prohibited, and that's what it says. Fred raised the 2005 Second Circuit case, Krauss versus Titleserve. I'm glad he raised that because we think that case actually strongly supports us. That case says that modifications under Section 117 are permitted only so long as they don't harm the interests of the copyright owner and are uses intended in the creation of the program. Now, Fred said the court there found, hey, these were not harming the copyright owner and intended within the original use. That's true because that was a program that was custom created for a particular business to operate its business. And it was very clear that the purpose for which that program had been created was to run that business. And so when a dispute arose between the original author, there was a question about whether the person who paid all this money could enhance it in a way that they needed to do to keep running their business while they tried to recover from the dispute, for example, by writing their own replacement. It's not surprising that the court said that was clearly contemplated within the original uses. Here, Apple put out a phone that they intended to have integrity in the operating system, and not be modified for all of the reasons you heard from Jaws. And this was very important to set up this level of trust that you saw in the diagram among the consumers, the partners, and Apple. This ecosystem wouldn't have existed if the carriers had not been comfortable that these bad applications would not be out there to run free rein on their networks. So there is clearly harm to the owner of the operating system here in a way that was not present in Craftsman TitleServe. In addition, you heard Joss talk about crashing applications, increased support burdens, piracy. Those are all things that are going to flow from jailbreaking the OS, and they certainly have a tremendous effect on the value of that copyrighted work. All right, fair use, let me just say briefly, and I also will refer you primarily to our papers for this, as did Fred. The burden of establishing fair use is on EFF, not on us. Congress gives us the right to put these anti-circumvention measures in, and if they want to claim that these uses are blessed by the fair use doctrine, the burden is on them. They've submitted no specific data to carry that burden as to why Apple's copyrighted OS or the market for developers' applications would not be harmed by jailbreaking. That's their burden. By contrast, Joss gave you a host of reasons why Apple will be harmed as the copyright owner by these jailbreaking. Problems with safety, security, operation of the iPhone, pirating of Apple's own applications and its developers' apps. EFF argues in its papers there's no harm to the market for the OS because Apple makes this available free and it does not sell it separately. That's an incorrect characterization. The OS software is not free, first of all. Apple sells the iPhone, and the price of the iPhone covers the hardware, it covers the OS, it covers the updates to the OS, and they certainly don't give it away for free. Second, the value of the OS cannot be assessed independently of the iPhone itself. The fact that people don't buy the iPhone OS without buying the iPhone doesn't mean that it has no independent value. Of course it has value. Its value is it's the center of the iPhone. The OS, as Josh showed you, is the center of the ecosystem. And the value of the iPhone is directly dependent on the value of the OS. It certainly has value. So under the fourth fair use factor, that harm is enough to stop the fair use analysis. As for the other three factors, I will just refer you to our papers. I'm also going to refer you to our papers on the statutory factors because I suspect, the debate is very clearly laid out there. I suspect you're going to have a lot of questions about those. Okay, so I've told you what I was going to tell you. I've told you. I'm now going to tell you what I told you. In conclusion, the jailbreaking exemption is really about circumvention of copyright controls on the iPhone. Copy controls on the iPhone, which the librarian has no statutory authority to grant exemptions for. So we're out of that process. That alone should stop the show. We've seen from Jaws' presentation that those copy controls protect many copyrighted works from unauthorized modification, copying, and piracy. This is not just about protecting a business model. What you may believe or not believe about those arguments in the unlocking panel, whether you accept them or not, that is not this case. This is a case about protecting the OS and the bootloader and Apple's copyrighted applications against modification. It's not just protecting the business model. And that protection against modification is the very thing that Congress intended in setting up the anti-circumvention provisions. They, in turn, have enabled an engine of innovation that you saw Jaws describe, 35,000 new works in 9 months, tens of thousands more to come in the next 9 months. If jailbreaking is approved as an exemption, serious harmful consequences are going to flow, not just to Apple, also to its consumers and its developer partners and its carrier partners. We urge the register to reject this exemption. Thank you.
Okay.
Thank you very much. In view of the time, I was inspired by David to try to come up with 3 points, but Actually, I think I have only one point that I wish to make very briefly, and then we'll open it up for questions. One point with two intensifiers, so I guess it adds up to three also. Here's my point. You have seen all this before. This is not a new exemption proposal by any means. This is the same proposal, basically, that you have rejected at least 15 times in the previous 3 rounds. You rejected it at least 5 or 6 times in 2006. Some people want to be able to run certain applications on a particular platform. The platform was not designed to do that, but through a business choice that was made by, in this case, well, Apple, but this isn't just about Apple, there's obviously a lot of other phone systems to which this applies. But they're frustrated, they want to run it on this. Perhaps they think that their spouse would be better off having it run on a different platform so that they could hear the alarm. I noticed it was the husband who thought it was the Razor phone was a piece of junk, not necessarily the wife. But in any case, they want this to run on a different platform. And the only way they can do it is to certify. And you have told them time and time and time again that that is not a sufficient reason to recognize an exemption. You told them in 2006, when you granted 6 exemptions, you rejected 11. And most of them fit this description. What you call space shifting was exactly an example of this. They wanted to run it on different platforms, different formats. DVDs that cannot be viewed on the Linux operating system. This is almost exactly the same point. It's not exactly the same, I'll get to what. Region-coded DVDs. We want to run it on a Region 1 machine. It won't run on a Region 1 machine. You said that's not sufficient because you can find another way to run it. Computer programs protected by mechanisms that restrict their full operation to a particular platform or operating system. Is that a good capsule summary of what we're talking about here? I think it is. You reject it because you said there are alternatives for making this non-infringing. And there are several other examples here, but my point is this is not a new claim. This is the same higher-level claim that you rejected several times before. It's not exactly the same for 2 reasons, and they both are reasons why you should definitely reject this proposal. The first one, which David has mentioned, is that the situation with 1201F, the existence of a statutory exemption that Congress adopted to comprehensively regulate the circumstances under which circumvention would be allowed for the purposes of interoperability of computer programs. That's what this is about, interoperability of computer programs. Congress explained when it should be allowed, when it should not be allowed, and at the very least, the burden has to be on the proponent of the exemption to explain, to demonstrate to you that they're not asking you to permit something that Congress specifically chose to outlaw, or that they're not asking you to make a decision that would, in effect, outlaw something Congress specifically chose to permit. If this is already covered by 1201F, then obviously you can't grant an exemption here because there's no the basis for granting the exemption would be absent. Now, you have grappled with this before in 1201J context in the security testing field. I think this is actually a much clearer case because Congress really set out to resolve the problem that we're talking about here, to decide the ground rules under which circumvention would be allowed for purposes of interoperability. So at the very least, it's the burden of the proponents to demonstrate that they can't bring their conduct within the scope of Section 1201F. If they can show that, then you can start to consider whether there should be an exemption recognized. So today, for the first time, 7 months, 8 months after we began this proceeding, EFF has given its analysis, I guess, of why 1201F doesn't apply, but I think the burden is on them to show that it doesn't. And that distinguishes it from many of the proposed exemptions that you rejected in the past, because they didn't deal with interoperability of computer programs. They didn't deal with an issue that Congress had already thought about and decided and set the ground rules for in 1998. And the second intensifier that I would point out really has to do with the effect of the circumvention that we're talking about here. No one seems to contest that one thing that will happen if this circumvention is allowed is that a very widespread platform will become a venue for infringing activity through the through playing pirated applications, pirated games, which can't be run on the iPhone today, can't be run on a lot of these other phones that are using technological protection measures, but will be able to be run on those platforms if the exemption is granted. So basically, the impact is going to be to open up vast new fields for the manufacturers and purveyors of pirated software, pirated games, of other pirated forms of copyrighted materials. That in itself seems to me is a pretty strong argument that it's been very difficult for the proponents to overcome that burden to show that not only is the use that they want to make it non-infringing, but that what they want, the conduct that they want you to accept is not going to lead to a proliferation of platforms for piracy. And I think, I don't believe they've met that burden, but that, again, perhaps more than some of these other exemptions that you considered and rejected in 2006 and 2003 and 2000, is another reason to reject this proposed exemption.
Thank you.
Thank you. I'd like to address this. I don't have 3 points. I don't have 1 point. I have 2 points. And my 2 points are that addressing the issue of whether the exemption would enable non-infringing uses. And I am going to argue that copying the iPhone bootloader and making changes to the iPhone OS are neither one infringing. And I'd like to address this from the viewpoint of how reasonable consumers expect their machines and their media to work and to be regular. There's a common sense distinction between products that do things like garage door openers, printer toner cartridges, computers, desktops, laptops, netbooks, handhelds, and protectable expression, visual art, music, books, motion pictures, graphic designs. And as Judge Merritt observed in his concurring opinion in the Lexmark case, auto manufacturers could control the entire market for replacement parts by using lockout chips. We're well accustomed to the idea that there's a distinction between the brand of a computing machine that we buy and what we see when we turn it on. We like that distinction. We fought hard to have it. You turn on an Acer, an HP, you get access to Windows or Linux. You can launch your web browser, you can launch Firefox, you can launch Explorer, you can launch Opera, and there was a time when you might launch Netscape. Software straddles the line between machines and media. There was a time when there was a big question about whether software was copyrightable. At the most fundamental level, software programs are written in machine language, binary code that only machines can read. And, of course, machines do not read. Machines execute. Execution is action, not understanding, not comprehension. The only people who read machine code are people who write instructions to control program execution. They are computer engineers who create digital machines that operate logic gates on microchips. They are engineers and they can be creative. Engineers create in 2 ways. Engineers may create devices of metal, plastic, genetic material, and they can obtain patent protection for them. And if they use linguistic tools to create original, tangible expressions that control electronic logic gates on microchips, they can obtain copyright protection for those works. From a common sense perspective, the idea behind a program cannot be copyrighted. To shoot a basketball through a hoop on a screen, to cause a guitar chord to play, to steer the image of a car around the image of a racetrack, those are concepts. Those are ideas that cannot be copyrighted. When it comes to the iPhone, the idea that cannot be copyrighted is turn on the phone, run an application. Any alternative way of doing those functions, of performing those activities, would be non-infringing if it were all alternative way of doing it. But suppose there is no alternative way of doing it because of external factors. The operating system itself, with which the bootloader must interact, the applications, the APIs that must be activated. If there is no alternative way to do it, then the Lexmark court says, and of course all of the cases that it cites, say that idea and expression have fused, and to copy that work is not infringing. Instead, it is simply the legitimate opening of a lockout code. Now, I am depending for my argument on the assertion by Apple that the bootloader is a quote-unquote small program. This is relevant. I don't have a copy of the program. I didn't think to request a copy of the deposit in time to get one, and other efforts to obtain the deposit from other sources are unsuccessful. However, if the program is small, the Lexmark court said, and it has a limited number of ways of doing a function, that all goes toward the conclusion that idea and expression are beginning to fuse. And if they fuse, then we do not have, even though it may have been issued, and certainly has been issued registration by the office, still it is not protectable. So the bootloader on the iPhone, if it is indeed just a small code that can only perform this function in one way or in a very small number of ways, of the variations of which wouldn't constitute real varied expressions, then we have a machine powered by an unoriginal expression. It's lockout code, and to copy the bootloader is not infringing. And the next topic, because I only have two, is making changes, derivative versions to the operating system. Now, it was interesting listening to the Virgin folks talking about how they wanted to separate the piece of plastic and metal that was the medium for the display of images and ringtones, and suggesting that somehow the sale of that object did not also result in the sale of those copyrighted works. It struck me that it was kind of like the publisher saying, you own paper, you own the ink. But the significance of these words is not yours. I see no distinction. It's the medium in which the expression was fixed. It seems to me absolutely clear that if the operation of the iPhone is dependent, it is just a machine, it is an hybrid, it doesn't have an operating system. If the operation of it is essential, and the only reason you would buy that machine is to buy its operation, then you own the operating system as well. 17 U.S.C. 117A1 allows the owner of the program to change a program if it is an essential step in the utilization of the computer program in conjunction with a machine. Again, looking at the reasonable expectations of consumers and protecting the copyrights of creators, we can see how the dividing line, examining the dividing line between the executable versus the expressive characteristics of software can help the office to make a decision that is appropriate assertion of its authority. 117A1 reflects Congress's decision that people and companies buy programs to run machines, not to appreciate the artful composition of hexadecimal code. And the machines are meant to be altered, adapted, improved, and developed further. To freeze a program's function at the original level of expression does something that is, un-American. It stops progress. The idea that the right may be relinquished, that what is stated in the Contu report is that
the right may be altered, that the relationship between the purveyor of a copyrighted work and the consumer, that can be altered by contracting. Exactly what that means, we're not sure, but we can be absolutely sure. A, that the Apple license is to be interpreted under California law, and B, that in California law, there cannot be the implied removal of statutory rights by implication. Contracts are not written so that one party can read an unexpressed intention into it later. The only way you can get an implied right out of a California contract is if that implied right is, quote, indispensable to effectuating the expressed intentions of the parties. And the intention to relinquish the right under 117A1, which is very, very fundamental, is certainly nowhere expressed there, and it would not be necessary to effectuate the intentions of the parties, one of whom only wanted to get a phone. Nor is this a hobbyist exemption, which I think Apple argues in its papers. I would just call it a hobbyist exemption because, if I understand them correctly, they say that the 117A1 exemption is confined to people who can retool their software personally. That's how they would interpret crops. And I have two reasons for why that does not work. One, there is no rational place to draw the line. Everyone uses tools to deal with software. Software owners should be able to use tools obtained from third parties to make planned, tested changes in software to enhance the operation of the machine. They shouldn't have to find some way to hook up their iPhone, see the machine language, make alterations in it, and then repackage it up. However people do that sort of thing. Nobody knows how. You have to use tools. And so there's really no place to draw the line. As Apple says, they created the SDK, the software developers kit. They have to give you tools. So in order to make those changes, it is just not rational, because the rational process for deciding what would be too much tool making can be used. A person should be able to desire. The question is, do they desire to make a change to their operating system so that they can alter the operation of their machine? And the idea that this is a copying, copying protection does not seem right to me, because as the panel, I forget which member of the panel, and maybe it was more than one of you, pointed out when Virgin was arguing, is there any market? Is there any market for cell phone operating systems free from cell phones? Is there any market for ringtones free from the individual machine? No. No, nobody is going to say, I made 35,000 iPhone operating system copies today, and I'm selling them, and I'm going to make a lot of money. And they only want the one that runs their machine. And they have the right to change it. And the second reason why I would argue against a hobbyist exemption under 117A1 is because, quite simply, it grants more rights to corporate owners of software than it grants to people. Because a company like TitleServe in Cross versus TitleServe can own vast numbers of machines, vast numbers of programs, and they can hire as many people as they want to make changes. In other words, a corporate owner can bring in employees and contractors to make these changes to the software that it owns. But an individual, a poor, unfortunate individual who only has the protections of the 14th Amendment, they cannot clone themselves and create another self that is smart enough to work on the software. So it's just one of those things that if you try and apply it, it doesn't work in the first place because there's no rational place to draw the line. How many tools do you get to use? And then if you apply it that way, it's going to give corporations more rights than people. And I fundamentally think that's unfair. Finally, I think that the term ecosystem is a very, very misleading term. But if we examine it, it shows us exactly what is not happening in the iPhone development universe. Because an ecosystem is not the product of a single command and control, brilliant top-down insight about what kind of life forms are going to appear in an ecosystem. An ecosystem appears from the wild collaboration and competition among all kinds of organisms operating in an environment that they actually have an effect on. They enrich it, they change it, they deplete it, they consume each other. That's an ecosystem. It is messy, but it isn't the purpose of copyright law to impose order on that. The purpose of copyright law is to protect the rights of creators, and in this case, I think, again, just to return to my original idea, if we look at that dual nature of the executable nature and the expressive nature of software, you can see the line, and it is expressions that are to be protected, and that is executable, is protectable only to the degree that it is also original and not fused with its purpose, or that Congress, with respect to 117A1, has given the owners thereof the right to make changes to. Thank you.
Thank you very much. Okay, I'm going to ask you, I'm not going to ask about section 117 because the case law is what it is. I know that. But could you respond to the Trump's allegations that the work that was registered in the Copyright Office may not be original or expressive or entitled to protection, and also the argument about the license and the fact that under California law you really can't basically suggest that a license can override what the law may provide.
Okay, sure. Well, first of all, on the bootloader point, the answer is pretty simple. He referenced Lexmark v. Static Controls, and the program there was found not protectable, and that was the toner loader program. I'll refer you to 387 F3rd at page 529, where the court says the toner loader program for one of the printers that was at issue comprises 33 program instructions and occupies 37 bytes of memory. The other one, for a different printer, was 45 program instructions and 55 bytes of memory. If you know anything about programming, that is a less than minuscule program. In fact, if you digitize the haiku poem, it would probably occupy 35 bytes. The bootloader is 10,000 lines of code. So there's no question this has originality here. It controls a number of functions. It is not merged with its functionality. It's a million times the size of the programs or whatever the math works out to be that were at issue in the Chamberlain case. With respect to the California law point that was raised, first of all, I don't share his interpretation of California law, and I think an awful lot of licensing lawyers would be very surprised by that interpretation, and do indeed believe that prohibitions on modifications can eliminate the Section 117 rights. But the broader point is, this exemption process is not here to argue about what California law is, or what Kentucky law is, or what New York law is. What the process is about is that the proponent of the exemption has to satisfy a burden that the uses that would be enabled by the exemption are non-infringing. We think they are not under 117 and under fair use. They have arguments why they are, but at a minimum, this is a very contested issue. And the office should be granting exemptions only where it is very clear that the uses that are being prohibited are non-infringing. It is far from clear here that these uses are non-infringing, and that can stop the inquiry.
Thank you.
One question. Fred, you've heard the assertion that we're really talking about copy control. More careful beyond copying actually explain to us why you believe we are in fact talking about an access control done by 1201.
Yes, this is simple. I think, quite frankly, David has misconstrued what it is we're asking, what the technological protection measure that we're asking to circumvent protects. We are not saying that we need to circumvent in order to access applications. This is circumventing access controls that apply to the firmware. So the simplest answer to your question, Apple's firmware is encrypted when it is distributed. It uses an archetypal access control measure. In order for the Ponage tool to create altered portions that can then be loaded in order to allow the phone to use other applications, it must decrypt the firmware, which again is distributed in an encrypted blob, in order to make the modification. That decryption is obviously not authorized by Apple. This is obviously a 1201A1 issue. I think the notion that this is a copy control is a complete red herring. That's for starters. And then, of course, even more to the point of to pile on top of what should already be obvious, of course, then each key checking operation up the chain controls access to the next layer of code. If that key check is not performed, the firmware is not decrypted and made available to the iPhone itself. So we are not talking here about a CD copy protection situation where the material is made freely available. There's just a measure that prevents copying, or something that would stop performing, or something like that. We're talking about a work that starts its life encrypted, and to which keys must be applied in order to decrypt it, both to adapt it and, in fact, to load it into memory. So, in my view, that's straightforward. Again, a red herring here. So creating the modified firmware requires access, and it's encrypted. I guess that's the clear answer.
Okay, David, John, is there anything accurate about what Frank said?
Well, it's just incomplete. How do people usually protect works against modification? They encrypt them. They put a password on. They put a handshake on. There's all kinds of different methods. We're not saying this is not that it's only a copy control. Things can be both copy controls and access controls. But the way you prohibit modification is you encrypt something or you put a password on it. And that is exactly what Apple did. Fred himself in his explanation just now said, what we want is to gain access to the operating system so we can modify it. That's the whole point. These things are encrypted so they can't be modified.
Well, then any time you use encryption, at least in part, to prevent you from modifying your code, then would anyone who hacks through that encryption be violating Section 1201B, regardless of whether they're ultimately can't be modifying the code?
I wouldn't go that far. But in this particular instance, what is being requested is jailbreaking. And what that necessitates, in their own papers they admit, is modification. So the reason they are gaining access to this OS, and the reason they have proposed an exemption for Ponage to it, is so that they can gain access to that OS to modify it. That is clearly a copy.
Well then, were we wrong? Have we been wrong with the past several years? Because the content scrambling system is an access control. Because I believe probably every use that anyone would come to us about with respect to circumventing the content scrambling system is ultimately that's something they can copy. Most of them have that anyway. So by your reasoning, I gather, it was wrong for us whenever we had it, and we have it often, at least there happened to be at least one occasion where we have come up with an exemption for content scrambling system on DVD, which has enabled people to make copies. I gather by your reason we were wrong to do that because content scrambling system in fact was serving as a copy control and the purpose of the people who wanted the media protectors who wanted to be able to circumvent that was to make copies. I guess we were wrong.
Well, I was not involved in the DCSS copy control hearings. I don't know exactly how that was argued and whether 1201B was even raised. So I didn't come in fully prepared to say you got that wrong. I just say if you grant something here that was put in place from the very beginning, that's the reason it was there. Apple's concern is that this OS get modified in ways that cause all of these things to happen. In the case of DCSS, there's content out there that people want to use in unmodified form. That's ultimately what they're trying to get. And that's sort of a quintessential access control, because ultimately they want to make a copy of something. Apple put this here because this is an OS. Your average purchaser of the iPhone is not interested in taking a look at the OS and saying, God, what a beautiful thing, I want to copy this. You know, that's not what they're interested in doing. What the exemption is oriented toward is modifying it, changing the way it behaves, the way it functions, and that's why it was encrypted in the first place. It's an OS. We don't want to have its functionality be changed. It's the heart of the phone. When its functionality gets changed, lots of things happen. The phone gets bricked sometimes. That has happened. It crashes in ways people don't understand. It's the #1 cause of crashes in Apple's log support system right now. And so that's why they set it up as a copy.
Of course, they use an access control to accomplish that. Just to clarify here, there's a little bit of confusion as well. We are not, with this exemption, seeking to legalize ownage tool, which the trafficking of which may, arguably, certainly I'm sure Apple would argue, would violate the trafficking provisions which Copyright Office is not entitled to grant an exemption to. I personally think the tool is probably covered by 1201F and therefore can be trafficked, but none of that is delivered to the Copyright Office. We are asking that end users who use tools like ownage tools not be exposed to circumvention liability for doing so. And that is a very different question. As you all know, there is no bar on a user circumventing a copy control. Congress deliberately left no prohibition on circumventing a copy control. There's only a prohibition on circumventing an access control. That's what we're talking about. The work is encrypted. That's an access control work. Certainly that's what everyone who's looked at this has assumed. It is encrypted exactly the same way DVDs are. So we're talking about users' ability to use the tool, and that's precisely what this exemption would be necessary for. And to the question which I think David sort of touched on, but the tools are illegal, so an exemption would be useless because the tools are illegal. Of course, that argument didn't stop the office from granting an exemption to the film professors, nor, in my opinion, is it illegal to download and use, or to be clear, it is not a violation of 1201A2 to download and use a circumvention tool. That is not trafficking in a circumvention tool. So it is not, I think, obvious that users are not allowed to have tools without violating the law, even if it may be illegal for people to distribute tools in a similar circumstance. And in particular, many members of the iPhone dev team are not located in the United States. And so if they are distributing the tool from abroad, they may not be violating any laws. Even if they're distributing here, I think they may not be violating any laws in light of 1201F. But in any event, the user does not violate any law by simply using the tool, or it doesn't violate 1201A2. The question before us is whether they need an exemption in 1201A1.
So can I just make 2 responses? First of all, we are concerned that the granting of this exemption will lead to massive infringements of 1201B in the form of users who say, great, I can jailbreak my phone, and so it's going to result in the trafficking of something that's illegal. But let me make a more important point. Fred is very focused on the end user and the end user having the right to do this stuff. As I argued, that the modified boot ROM that the user creates in the phone is itself a device that is there only for the purpose of circumventing the copyright controls on the OS. The user is doing activity in 1201B, not just the makers of the phones.
But there is no bar in 1201B. 1201B only prohibits trafficking. Nothing we're talking about, the user won't be trafficking, and therefore that question.
No, that's missing the point. 1201B prohibits the manufacture of a device whose sole purpose is to circumvent. This was a prophylactic measure. It's the same kind of prophylactic measure Congress puts in all of the piracy statutes. They want to reach not only the act of the distribution and the trafficking, but also the manufacturer that leads to the trafficking. So if somebody does the manufacturing, even if they never distribute it, they're still in violation. And this is not the only case where Congress has set something up that way. They've done it in the movie space, they've done it in the recording space. Those industries have urged them to outlaw manufacturing as well as distribution. So distribution is not the only thing that triggers 1201B.
So, let's be clear that I understand what you're saying. You're saying that when an individual essentially creates a circumvention tool solely for his own use, doesn't ever give it to anyone else, just creates it, maybe creates might be an overthing, if someone else gives him the software when he loads it, it does it. That's a violation of 1201B.
When it does it in this way and creates that modified boot law, the user is creating a circumvention component. If you look at 1201B, it talks about devices, technology, and component. They're creating a component whose only purpose is to then circumvent the copy controls on the OS.
But that just doesn't really fit, because the problem, I'm trying to put this into some perspective. 1201B would only cover the trafficking services of circumvention that protect the rights of the copyright owner. So if in this situation, the only thing that could fit that situation, an individual user who wanted to hack that is free to, because Congress left that space open. So the only person who could be liable then would be somebody trafficking in a device or service. And in this case, perhaps that could be Honage as a tool. Have there been any lawsuits against devices or services that circumvent this use and access control?
Have there been lawsuits under 1201B against services? Yeah, in the phone industry.
Well, is it true that Honage is the most widely used tool today? And so has there been any action against that device?
Oh, I didn't come prepared to answer.
And then, because then the harder question then is if under something like that, a particular tool is created that falls within 1201B, if that is then used by an individual to accomplish what is not prohibited by an individual act of circumvention. So the state that the individual act of circumvention of a use control, since there is no prohibition on that, if that was the only problem, then if there was nobody to stop the tool, then that tool could get out to an individual, and the individual could use that to hack through the measure that protects the rights of the copyright owner. What it can't do, it can't traffic in a tool that protects access to the copyrighted work. And so the question here is what kind of tools are these? What kind of technological protection measure is it that is protecting them? Now, I heard that you were at least willing to say that this is and the question David asked, that this is perhaps both in your view, like some other. It has the purpose of protecting the rights of the copyright owner by encrypting, by essentially being an access control.
Well, I'm not saying that this is an access control that happens to protect the rights of the copyright owner. I'm saying this thing was designed from the very beginning to be a copy control. That's why it was designed into the iPhone. Prohibit modification. Let me just, I don't think we should get too lost in this 1201B label of trafficking, so maybe it's not useful. Let me just be clear to the point that I'm making. The point is that when you use the word trafficking, if what you mean by that is just distribution, then I would say that 1201A2 and 1201B both prohibit more than just distribution. They also prohibit manufacturing. Now, I am not aware of any cases that have construed the term manufacturer under 1201B.
But the
So-
individual who uses a device that was manufactured is not traveling. So, or manufacturing, they're just using that to accomplish circumvention. But maybe we shouldn't get too caught up in that.
Let me just point out that this is frankly irrelevant to the question before the Copyright Office today, because obviously the Copyright Office cannot grant exemptions to a non-existent prohibition on circumventing the copyright rule, nor can it grant an exemption to 1201B, the actual 1201B we have.
If there isn't any access control, then we shouldn't even be sitting here. But we're assuming now that there is an access control, that this is protecting access to the copyright work, and that then the question is, if somebody's using another tool to do that, there isn't Congress did create a bar, a prohibition, a circumvention of an access control, so that would be a problem within the scope of this rulemaking of whether an individual could use something like Menage or some other tool to circumvent.
Can I just make one last point and I will stop? What I don't want to get missed here is that the way the exemption is worded, it could cover activity by the end user that is prohibited by 1201B, and the office is not empowered to do that. We wouldn't report to.
And nor are we asking you.
In terms of, well, let me ask one basic question. Fred, do you believe that when someone jailbreaks a phone, that Apple should still respect the warranty?
No. And I don't believe they owe them any support, nor do I believe people who make apps in the App Store owe them any support. None of that is the issue here, just as I wouldn't expect my Toyota dealer to respect a warranty after I added a turbocharger to my car.
So essentially, users are on their own if they jailbreak their phone, and Apple owes them no further duties or obligations.
And in fact, Apple has made that repeatedly clear. In fact, it's well known that Apple stores will refuse to service or replace iPhones that have been jailbroken. That's all the standing policy.
Now, there was some question. I saw some discussion in the comments that this was creating a substantial financial problem for Apple because is there not a way to quickly be able to identify a jailbroken?
There's not. That's why that may work if somebody can actually walk into the store and see that. It's not always clear. It's not always clear to the customer why they're having a problem either. And the phone doesn't filter whether the telephone call to Apple doesn't have any way of filtering whether that phone was jailbroken. It's still a support call. And that customer expects support because, again, they have no idea that what they did has made their product as unstable as it has. Why should they? There was nothing that came from the phone-ish people that said, by the way, your phone's going to crash a lot when you do this.
But just like one thing, it may fail to, you may not be able to update the iPhone afterwards, right? So wouldn't maybe one step be to just verify that it was, before going any further, verify that there was a problem or the integrity of the system had been.
Well, that can happen at the time of a software update if the software was damaged by a tool. Ponish wasn't a specific example I was referring to where the damage. That was done by some other software that actually, in trying to unlock the iPhone, it damaged the software again in a way that couldn't be updated. But again, Ponish is just an example, right, of software that goes through these types of steps to hack the iPhone and modify the OS. Once you modify things, again, anything can happen. And it's hard enough when we modify. This is, as you know, a very sophisticated product. It's hard enough when we modify things in a very intended way to make sure that we're managing and not regressing and not causing problems in other areas. There's a lot of work necessary to do that. As soon as hackers start doing it, all bets are off, and that's why the phone becomes as unstable as it does. And again, there's just no denying that. And customers don't realize that. It still looks like an iPhone to them, but they've damaged it in some way that, or certainly it affected the performance and stability of that phone.
So if there's no denying that, do you deny that?
No one accidentally jailbreaks their phone.
So the users are well aware that they have jailbroken their phone, and Apple and everyone is welcome to explain to them the risks.
But can Apple find out easily and quickly if a phone has been jailbroken?
Apparently they can, because in their own comments they point out the following number of calls have been from jailbroken phones, the following number of crash reports have been from jailbroken. So
although it takes them a very
Exactly
long time.
the right point, Robert. It takes a lot of cost to get there. And again, these are disproportionately high rates of crashing. And the customer doesn't realize that that's why the problem they have is the problem they have. They just go, my phone crashes a lot. Damn Apple. You know, that goes back to the whole point of damaging a brand. They had no idea that what they did just to install this app to get this SMS to ring multiple times, which by the way we do, I think you should update your user, we actually have that functionality. But anyway, you know, they don't realize the problems it causes.
So I think you just heard the basic point. This is about protecting a branding concern, not about saying that this is infringing, not about protecting the copyright interest in the firmware. This is about a branding concern and frankly not relevant to DMCA. Apple has many other avenues available to it. In fact, when asked about this very issue, Steve Jobs, CEO of Apple, answered, well, you know, we play a cat and mouse game with the folks who develop these things. We update the code, it disables versions that are jailbroken. This has happened repeatedly. So it's not as though Apple is left powerless to control their support costs. They, in fact, are engaged in very real efforts to minimize this. And I don't, again, let's have that. That's the traditional market when you try to create a closed ecosystem.
But that wasn't what I heard. I think what I heard was that they currently don't have an easy way of identifying that. So it would put these together that okay, you admit that they should be able to jailbreak and that would void the warranty. If we could have that clear at that point, and Apple knew that, wouldn't have to touch it anymore, then perhaps that would simplify this problem. And some of the other concerns, because there are a lot of other concerns: crashing, instability, malfunction, safety, privacy, offensive content, viruses, inability to update. Well, that may affect copyright. But many of those other ones, while laudable goals, are probably not copyrightable features in terms of those do have more to do with the market. But if Apple has no way of identifying that then there is significant cost to the copyright owner in terms of continuing to try to service what they only much later on identify as a legitimate phone.
Again, the simplest way to determine this is ask the user, did you jailbreak your phone? No iPhone owner accidentally jailbreaks their phone. It's a relatively involved process. And so if the owner lies to the support call, then I don't really have an answer to that. But that's no different than if you ask the person whether or not their phone was still in warranty and they lied to you. Right? The quickest way, if you can physically examine the phone, that's easy. You will see there are applications that are not from the App Store, Cydia being the sort of most obvious one, the alternative App Store. If the person is calling, you can just ask them.
But there are easy ways to find out whether something's still under warranty, right?
If it's under warranty, sure, we know that. And that part's easier, setting aside from being jailbroken.
Could I just add one point on this about whether these are copyright injuries or market injuries or all of the other things that were mentioned there? I think maybe you just haven't gone to this yet, but it's clear what Congress was intending to do in enacting 1201 was to encourage copyright owners to use these technological protection measures in order to, among other things, increase the promote the development and dissemination of copyrighted works. I think the evidence from Apple is that it is succeeding in that role. And some people don't think 35,000 applications is enough, or the wrong applications or something like that. But I think if you look at it in the broader context, is this the market developing the way Congress intended and wanted use facilitating technological protection measures to be promoted, and did it direct the Copyright Office to allow an exemption, to allow the circumvention of these highly successful, if you accept this evidence, use facilitating technological protection measures. Now, you could characterize that as protecting the brand and the ecosystem and so on and so forth, and those don't necessarily sound like copyright terms. But if you look at the intent of the statute and what Congress asked the Copyright Office and Library to do, I think it fits pretty well that this type of harm, this type of injury, may be a strong argument against recognizing the exemption.
Well, since this is an operating system essentially in this device, would Apple, would any computer company be able to prevent somebody from putting particular programs that were not preferred on their computer, or not being able to utilize some...
Can they do that technologically, or can they do that legally? The answer is yes in both cases.
Legally and technologically, then why is it different? Because this is a modified, on the iPhone, it's a modified Apple OS operating system, right? So really we have a little computer. And why is a phone more vulnerable to all these problems that computers and laptops are pretty robust as well and could cause many of these other problems? If it's all legal to do on a computer, why is it illegal to do on a computer that is also...
Well, you're talking about the market impacts and the practical impacts of it, and that's the way that market is developed. But the real question is, did Congress intend, when it adopted the DMCA and gave you authority to recommend exemptions, that it was hostile to the idea that a copyright owner would be allowed to determine which applications could interoperate with its software? To the extent it was concerned about that, it enacted 1201.
Could they then, you said it was legal and technologically feasible to do that with a laptop. So if there was, is it only legal because there's no technological protection measures that's preventing people from doing it on a laptop? Or
if I wanted to come out with an operating system for a laptop today that only that was not open and did not allow a lot of interoperability, I could certainly do that if I wished. It might not be a very smart market decision, but I certainly could do it. Is there a legal impediment to my doing it? No. It might be a market impediment, something that would make it a bad idea, the way the market for computers has developed. Well, I agree that it's getting a little harder to draw the line between the phones and the computers, and we talked about this earlier, of course, in the earlier session. But the fact is, the markets are different.
And protecting the OS from modification is not unique to the iPhone. Again, PCs, other phones protect their OS from modification.
And I want to make a point that I hope isn't getting lost here. Apple did not put these measures in simply to protect their brand. I mean, this is not all about protecting a brand or something. Somebody said that. We put up those as examples of damage that is going to flow from undoing the protection that Congress entitled us to have. Those are examples of what's going to ensue. And you, in your notice of inquiry and every hearing that you've had, have said we have to balance the benefits of the protection measure against the harm, and the benefits of the exemption against the harm. All of those are in play. We're trying to let you know there's some real harms here that you need to take into account. That does not negate the fact, though, that there's still a modification going on here. That's a copyright interest. It's a derivative work. It's an unauthorized modification that we believe is infringing. It is a copyright issue.
Only if 117A1 is not effective to protect the owner from making that modification.
One other thing we have to look at is what the likelihood that during the next 3-year period this is going to be a problem. To what extent have problems existed that, or the desires that people have, are they affected by the market in terms of somebody wants a particular feature on an iPhone within some period of time, perhaps within a 3-year period of time, that feature becomes available on the iPhone. Does that happen?
Do we introduce new features that customers want?
Right.
Clearly, even in Fred's example, we've addressed that customer's need of having the repeating SMS, and actually it was driven by doctors who requested that. We add literally, hundreds of features since we've introduced the iPhone. The iPhone OS 3.0 that we're introducing this summer has over 100 customer features. It has over 1,000 developer APIs coming out this summer. So clearly, we keep moving this forward and addressing the needs of our partners and our customers.
And a larger point here is, Fred has some anecdotes of some people that wanted a particular feature. But it hasn't satisfied the showing. Is this widespread? Are there tens of thousands of people, that want these apps? I mean,
there are hundreds of thousands. We have a showing in the record. There are 1.8 million jailbroken phones, over 400,000 in the United States. There are obviously a large number of users involved here. That's in the record. So, sure, Apple does introduce new features. Some of those features they reserve solely for their own software in order to prevent competition on the iPhone. Some of the new APIs, there may well be over 1,000 APIs for developers coming out this summer. There will, however, continue to be other APIs that will only be available to Apple developers. This is, again, it's not directly copyright interest. I think the thing to underscore here is, what are we talking about? Unlike what Mr. Metalist suggested, this is not the you want to play your DVD on in a toaster problem, as he suggests. Right? The work that is being protected by the access control is the firmware. Are there alternatives to the firmware on the iPhone? No. Right? There is not I can go find a firmware somewhere else to use on my iPhone. You can only use the firmware that is available, particularly the bootloader and all the OS components that Apple has provided. So there is not an alternative in the sense that you could go play your DVD on a different player. You could go get the same movie on VHS. The work that is being protected is the operating system, and there are not other alternatives for the operating system. There may well ultimately be applications that are available on other things, but that's not what this exemption is about. We're not asking for an exemption to circumvent access controls on applications. We're asking for an exemption to circumvent access controls on the operating system.
The only reason for asking for it is to run applications on this platform. You could play your DVD on, if you can't play your DVD on Linux, you could play it on a CSS compliant machine.
But
every 3 years, people come in and say, we should be allowed to circumvent so that we can run applications on the platform we want to run it on instead of the platform that's designed to run on.
And all of those,
that's what this is about.
That is not true. All of those exemptions have sought exemptions to circumvent access controls on those copyrighted works, the movies, the video games. That is not what this exemption is about. This exemption is about circumventing access controls on the operating system.
So I'm
a
little confused. So you would presumably support the exemption if it was conditioned so that it didn't apply to running any applications on the operating system that you gained access to?
Absolutely. I don't need an exemption to run applications. The applications don't have access controls on them.
But in other words, if you circumvented and for the purpose of running an application, that would be outside the exemption. So if that's the case, then that probably would be acceptable.
We're not asking that. The exemption process is not about the purpose. It is about the access control on the work and whether there are alternatives.
Yeah, we have to. I'm a little confused by Fred's point that there's no alternative for the customer of the operating system. We represent less than 2% of the market share of phones in the world. Customers have other choices. We are abundantly clear as to what the rules are on the iPhone and how we've gone to market. There are alternatives. It seems to be working for a lot of customers. And again, the iPhone, as I talked about, is #1 in customer satisfaction. It seems to be working, but they do have alternatives.
And let me just follow up. Fred just justified to you his showing of harm by saying there's 1.2 million or 8 million or whatever it was, customers who jailbroken their phone because they want to run apps on the iPhone. That was the whole showing he said they've made. This is being justified on the ability to run the apps on the iPhone as opposed to another phone. That's where the 1.8 million comes from. And in all of the, Steve is correct, in the other exemptions that you guys have considered, you have noted that if the ultimate use, the non-infringing use of the work that someone wants to make can be done on another platform, The inconvenience is not a reason to grant an exemption. They've said that many times, and the same applies here. There are other phones on which these apps can be run. It's just that Fred would prefer a world, and many of the people out there would prefer a world where they can run those apps on the iPhone. But nothing about copyright policy or the DMCA policy says that a copyright owner is required to open up the use of its copyrighted work to the entire world. If to use it in ways that were not intended require you to infringe the copyright, that's why the DMCA exists.
If it were the case that this infringed copyright, Mr. Hayes would be correct. This does not infringe copyright, and the whole purpose of the rulemaking is to permit exemptions where non-infringing uses, in this case, the creation of an adapted version of the operating system for an obviously non-infringing purpose. No one here has suggested running legitimately acquired software from unauthorized, from places other than the App Store is somehow infringing. So I'm happy to engage on this question of whether or not jailbreaking your iPhone infringes. I think we've already talked about this in the context of 117, but from my perspective, it is non-infringing. We disagree about that. Assuming that that's the case, it's exactly in the heartland of what the rulemaking process is.
But you made a point about it's not infringing for the end user to make the mod. We disagree on that. But then the end user has to take the modified OS, load it into RAM, and run it. And I can cite you a slew of cases that have said it started with MAI versus P. There's a whole line of authority that says when you load a copy, an unauthorized copy, into RAM and run it, you're a copyright infringer.
That would make 117A a dead letter, because every time you adapt code under 117A, you
We will analyze the paper
Of course,
under
of
section
course,
117
of
and come
course.
up with an answer. Unless you want to dedicate yourself to spending Friday evening with us. And then Rob has one more question, and Ben has some questions.
And just to follow up, the last question, you can be rest assured that you will, without question, get further questions. That in terms of 117A, Fred, just explain to me how this works in terms of this situation, because the way I read that is that in terms of making the adaptation of that computer program, that such a new copy or adaptation of that program is created as an essential step in the utilization of the computer program, that computer program, in conjunction with a machine, and is used in no other manner. So this would be adapting the program so that it would work on a machine, right? And it's not a question of whether it would work on it would make other computer programs work on the machine. If you purchase it, so.
Right, and that's absolutely right. I agree. The point here is the adaptation is made in order to run on the machine with which it was originally intended to run, namely the iPhone. That right there,
computer program,
the operating system, the firmware.
Okay, and how does the other app fit into this equation that's created by the third party?
It doesn't. It's not relevant, right? The point is the only arguably infringing event occurring here is the creation, possibly, of a derivative work from the operating system. As you saw on the screen, the creation of a modified bootloader and a modified version of the operating system. That is the only arguably infringing act involved here. And so 117 excuses the creation and use of the adaptation of the operating system. There is no infringement when you go and purchase an application from an independent app store.
But doesn't this envision the fact that the computer program would not work with that machine or device in the first instance, which is why you have to adapt it? So here, the operating system bootloader works perfectly well with the machine or device. It's just that you want it to do other things.
Right, and 117A is intended to accomplish exactly that, as Krauss versus Title sort of makes clear. They had software that they needed to adapt to do other things. And that's what the Second Circuit said was all right.
Yeah, so obviously we disagree with that interpretation of Krauss and Title. Fred's initial argument proves way too much. He said, look, as long as you're adapting this thing to work on the same machine for which you purchased it, it's under 117. Well, if that was true, we wouldn't have had Crosby title served. That's not what the Second Circuit held. There are some boundaries around the scope of the adaptations you can make under Section 117. And just because you're using it on the same machine, it's not a talisman that says, I'm in 117, end of argument. That's not the holding, Crosby.
And I don't dispute that, and I'm sure you will all read page 13 and 14 of the Compu report, as we both have, and I trust you'll come to your own conclusions.
Everyone agree that Krauss is good law, whatever it is?
Yes.
Yes. Okay.
So less than 4 years old out of the Second Circuit are we now in copyright.
For that matter, sort of the only case to fully ventilate those sections of the statute, so we don't really have much else to go.
Let me ask you, I'll direct you to Apple. You said about your relationship with AT&T. I'd just like to know, does AT&T require you to prohibit certain applications?
They do have certain rules to their customer and their terms of service of what kind of applications are allowed. We have tried to be sensitive certainly to our partners, and again, as I mentioned, there's 30 of them at last count around the world to again make sure that the applications that we're allowing in continue to allow their networks to be viable. For example, you saw on my slide that we don't allow in bandwidth hogs. Well, generally the nice thing is what that results in when we find an application that gets submitted and is using too much bandwidth, most of those are fixed in conversations with the developer as to how to do things more efficiently. But again, the important part to realize is these networks are shared by everybody, whether you have an iPhone or not, and we have to be sensitive to how the phone uses and the iPhone applications use that network.
Can I just point out that there are plenty of GSM networks that permit mobile devices that are capable of running any application. It is not the case that GSM operators live in fear of general purpose computing devices that happen to have mobile phone radios built into them. One need only look at BlackBerry, all the Windows mobile devices, none of which have the same you must only run approved applications requirements, and those phones run fine on other GSM networks. Obviously the G1 phone is much more open, not as open as we'd like, but much more open, and T-Mobile doesn't appear to have a problem with that. So those are counters.
The big difference is, and again, why this has been such a revolution, as I've mentioned, is the fact that we deliver the App Store on every single device, through every single carrier, whether it's an iPhone here in the US or in Europe or in Asia, and that has, again, the ability to deliver those applications to every customer developer has access. Before the iPhone and the App Store, what had happened is that applications were very difficult to get through the carriers, because the carriers are the gateway to what can run in their network. When you bought a phone completely unlocked and away from their network, then certainly, yeah, there were things that you could do. But the phones that were delivered through that carrier, it was very difficult to get applications. And again, it was us establishing that trust that we could deliver this App Store without them being the gatekeeper, because they are not the gatekeeper. We are. We control the product. We control the products that we sell through the App Store, not the carrier. That, again, has been very different than what has existed in the mobile industry before the iPhone and the App Store.
Tell me this, I read somewhere that you can't get an iPhone in Vermont or in Alaska. Is that true?
Vermont is one of those northeast states doesn't have a GSM network, doesn't have the towers. I'm not sure if that's still the case or not.
Now that Justice Souter's retired, he'll have it.
If that's important, I can follow up.
You also said that Apple cuts 30% of the revenue from the apps that are sold. Does AT&T or your other partners get any cut in what's sold?
No.
Okay. And this is a three-part question, and give you my time. Tell me the process of approving.
And part of that, I can tell you, there's not a whole lot left over, by the way.
Tell me the process of approving an application, of rejecting an application, and removing an application.
Say that again, sorry.
So approving an application, you tell your people you have a standards of practices manual that you have.
Yeah, we have reviewers that have the checklist, the guidelines as to what can be approved and what not.
And that goes to a chain of different people, make sure that people make the right decision.
It does.
And so when you reject an application. And this is, you said that you accept 96%. So you reject 4%, but you tell me in real numbers, how much is 4%? Is it a million? Is it 100,000 that you reject?
Well, you can do the math. We have 35,000 out there now. Certainly, again, one of the important parts to add, by the way, Ben, is the fact that when we reject an app, oftentimes, or number one reason, by the way, is it crashes. It's buggy. But in nearly every case, we try to figure out how we can get that application approved to the developer. The developer will go back to the developer, tell them why it was denied, and willing to work with them to figure out what do they have to do to fix in that application to get that application approved. Because again, it's in all of our interests to get applications up on the App Store. It's in our customers' interest, it's in our developers' interest, it's in ours. Just got to make sure that it adheres to the rules.
Let me just point out, there are a number of rules that mean certain categories of applications don't get submitted at all, because it's clear from the rules Apple will not accept them. And that's part of what prompted Mozilla and Skype to file on our site.
So I read somewhere in an article in one of the journals about that you have non-disclosure agreements for people who get rejected, that they're not supposed to say anything about why they're not rejected.
Well, the program itself has some non-disclosure rules. I don't have anything specific to the rejection letter.
And I got an article that this stuff, so that's all I'm asking. And lastly, in this three-part question about removing, how do you determine when to remove a program? Speaking about the controversy from last week with the chicken bacon application, who decides that and how does it work?
Well, again, it's a similar process. Obviously, there's escalation when something has been found to be approved. And we should know that was a good example last week. It was something that we regretted having seen get approved. We were unaware of it at senior levels until it became aware through the press. And of course, we immediately had to withdraw. There aren't many cases.
So if there's consumer anger, then you pick them again at the same time.
There could be multiple reasons. I think one of the things that EFF cited in their paper was that somehow we were giving Google preferential treatment if they were using a private API, which is probably worth maybe even another quick aside. It's private APIs that they discussed that maybe Apple only uses. Generally, our APIs that we're still working on, they're not done, and we haven't published them. And the reason for that, again, is, we test our APIs, under lots of use cases. When we're developing an API for a developer and it's not fully tested or not fully baked, we don't release it. If a developer uses that private API, that's against the rules. They cited that there was a Google application that had used the private API, and somehow, that was okay for them because they were a friend of ours. It wasn't okay. It was, unfortunately, we didn't realize that when the app was approved. We went back to them. They, fixed it and resubmitted the app in a way that everybody was happy.
And this is just an overall thing, and please I'll follow up later, but is there any First Amendment issues that we should be concerned about? In the sense that we granted exemption to these applications that we don't want to have on the store are accepted to that we aren't validating constitutional issues?
Well, I didn't come here prepared to
Nor
engage you
I, JD.
on the First Amendment or constitutional issues, but what I would say is that has nothing to do with the criteria that Congress has
Well,
told
if
you
you
to look
look
at.
at that,
Yeah, but the primary criteria is, are these uses infringing, and are they even affecting a...
Then is that question whether they're a state actor?
well, there's no say. Right now there's no constitutional issues because there's no government involvement, but we are now in the steps of either approving or rejecting an exemption. I was wondering if that we had something to do with speech involved.
Well, there is a speech provision in the DMCA, and that would be applicable in this case. So if there were some First Amendment problem with a 1201A1 case that, let's say, Apple brought, I think that we would look to that to see whether. Probably it's not a question of the exemption, it's just a question of the underlying law.
Ben, if you do have a specific question on that, seriously, I didn't come in to talk about the First Amendment, so I'm unprepared to answer. If you have a question about that and you think it's relevant to the decision and can tell us why, we'll put it to us and we'll respond in writing.
Let me just point out on your last question, about the APIs, and this was brought up here. While it may well be the case that Apple sometimes holds APIs until they're fully tested, that's certainly not always the case. One API that independent developers and authorized developers have complained about from the outset is Apple reserving the right to run applications in the background solely for its own applications. So I'd encourage you next week, you'll have the opportunity to talk to an actual app developer who can answer some of those questions in more detail.
And since you brought that up, and I'll address that if it's okay, we hate background applications in general because they suck battery life from the product. Background applications can take as much as 80% of your standby power away. Not to mention this, they compete for performance with the foreground applications, again, in a way that customers don't understand. One choice to answer that is to present customers with a task manager, some way for them to manage the applications that are running, but as I said earlier, try to create a product that's for regular people. So we've given another way to solve that with our iPhone OS 3.0, which again, we've given what's called a push notification system so developers can solve 80% of their needs at the very least with this system, and again, notify customers through a much more battery efficient single pipe that we provide into the iPhone.
Until then, only Apple applications will have the right to run in that mode. That's the problem.
Okay. Well, this has been the end of a very long day, and you're the last panel, and I thank each and every one of you for helping us try to get through the proposed exemption. I think we will be getting questions, and especially even maybe not right away after next week when we learn more and crystallize our thoughts a little bit more. But again, thank you, and enjoy the rest of the evening.
Thank you.
Thank you.